Historical background: The British came to India in 1600 as traders, in the form of East India Company, which had the exclusive right of trading in India under a charter granted by Queen Elizabeth I. In 1765, the company, which till now had purely trading functions, obtained the Diwani, i.e., rights over revenue and civil justice, of Bengal, Bihar and Orissa. This started its career as a territorial power. In 1858, in the wake of the Sepoy Mutiny, the British Crown assumed direct responsibility for the governance of India. This rule continued until India was granted independence on 15 August 1947. With independence came the need of a constitution. As suggested by M.N. Roy, a pioneer of communist movement in India, in 1934, a constituent assembly was formed for this purpose in 1946, and on 26 January 1950, the constitution came into being. However, various features of the Indian constitution and polity have their roots in the British rule. There are certain events in the British rule that laid down the legal framework for the organization and functioning of government and administration in British India. These events have greatly influenced our constitution and polity. They are explained here in a chronological order. The Company Rule, 177318858, Regulating Act of 1773. This act is of great constitutional importance as a. It was the first step taken by the British government to control and regulate the affairs of the East India Company in India. B. It recognized, for the first time, the political and administrative functions of the company, and c. It laid the foundations of central administration in India. Features of the Act 1. It designated the Governor of Bengal as the Governor-General of Bengal, and created an executive council of 4 members to assist him. The first such Governor-General was Lord Warren Hastings. 2. It made the governors of Bombay and Madras presidencies subordinate to the Governor-General of Bengal, unlike earlier, when the 3 presidencies were independent of one another. 3. It provided for the establishment of a Supreme Court at Calcutta, 1774, comprising 1 Chief Justice and 3 other judges. 4. It prohibited the servants of the company from engaging in any private trade or accepting presents or bribes from the natives. 5. It strengthened the control of the British government over the company by requiring the Court of Directors, governing body of the company, to report on its revenue, civil, and military affairs in India. Pitt's India Act of 1784. In a bid to rectify the defects of the Regulating Act of 1773, the British Parliament passed the Amending Act of 1781, also known as the Act of Settlement. The next important act was the Pitt's India Act 2 of 1784. Features of the Act 1. It distinguished between the commercial and political functions of the company. 2. It allowed the Court of Directors to manage the commercial affairs but created a new body called Board of Control to manage the political affairs. Thus, it established a system of double government. 3. It empowered the Board of Control to supervise and direct all operations of the civil and military government or revenues of the British possessions in India. Thus, the Act was significant for 2 reasons. First, the company's territories in India were for the first time called the British possessions in India, and second, the British government was given the supreme control over company's affairs and its administration in India. Charter Act of 1833. This act was the final step towards centralization in British India. Features of the Act 1. It made the Governor-General of Bengal as the Governor-General of India and vested in him all civil and military powers. Thus, the Act created, for the first time, a Government of India having authority over the entire territorial area possessed by the British in India. Lord William Bentinck was the first Governor-General of India. 2. It deprived the Governor of Bombay and Madras of their legislative powers. The Governor-General of India was given exclusive legislative powers for the entire British India. The laws made under the previous acts were called as regulations, while laws made under this act were called as acts. 3. It ended the activities of the East India Company as a commercial body, which became a purely administrative body. It provided that the company's territories in India were held by it, in trust for His Majesty, his heirs and successors. 4. The Charter Act of 1833 attempted to introduce a system of open competition for selection of civil servants, and stated that the Indians should not be debarred from holding any place, office and employment under the company. However, this provision was negated after opposition from the Court of Directors. Charter Act of 1853. This was the last of the series of Charter Acts passed by the British Parliament between 1793 and 1853. It was a significant constitutional landmark. Features of the Act 1. It separated, for the first time, the legislative and executive functions of the Governor-General's Council. It provided for addition of 6 new members called legislative councillors to the council. In other words, it established a separate Governor-General's Legislative Council which came to be known as the Indian Central Legislative Council. This legislative wing of the council functioned as a mini-parliament, adopting the same procedures as the British Parliament. Thus, legislation, for the first time, was treated as a special function of the government, requiring special machinery and special process. 2. It introduced an open competition system of selection and recruitment of civil servants. The covenanted civil service 3 was thus thrown open to the Indians also. Accordingly, the Macaulay Committee, the Committee on the Indian Civil Service, was appointed in 1854. 3. It extended the company's rule and allowed it to retain the possession of Indian territories on trust for the British Crown. But, it did not specify any particular period, unlike the previous charters. This was a clear indication that the company's rule could be terminated at any time the Parliament liked. 4. It introduced, for the first time, local representation in the Indian Central Legislative Council. Of the 6 new legislative members of the Governor-General's Council, 4 members were appointed by the local, provincial, governments of Madras, Bombay, Bengal and Agra. The Crown Rule, 18581947, Government of India Act of 1858. This significant act was enacted in the wake of the revolt of 1857, also known as the First War of Independence or the Sepoy Mutiny. The act, known as the Act for the Good Government of India, abolished the East India Company, and transferred the powers of government, territories and revenues to the British Crown. Features of the Act. 1. It provided that India henceforth was to be governed by, and in the name of, Her Majesty. It changed the designation of the Governor-General of India to that of Viceroy of India. He, Viceroy, was the direct representative of the British Crown in India. Lord Canning thus became the first Viceroy of India. 2. It ended the system of double government by abolishing the Board of Control and Court of Directors. 3. It created a new office, Secretary of State for India, vested with complete authority and control over Indian administration. The Secretary of State was a member of the British Cabinet and was responsible ultimately to the British Parliament. 4. It established a 15-member Council of India to assist the Secretary of State for India. The Council was an advisory body. The Secretary of State was made the Chairman of the Council. 5. It constituted the Secretary of State in Council as a body corporate, capable of suing and being sued in India and in England. The Act of 1858 was, however, largely confined to the improvement of the administrative machinery by which the Indian government was to be supervised and controlled in England. It did not alter in any substantial way the system of government that prevailed in India. 4. Indian Councils Act of 1861, 1892 and 1909. After the Great Revolt of 1857, the British government felt the necessity of seeking the cooperation of the Indians in the administration of their country. In pursuance of this policy of association, 3 acts were enacted by the British Parliament in 1861, 1892 and 1909. The Indian Councils Act of 1861 is an important landmark in the constitutional and political history of India. Features of the Act of 1861 1. It made a beginning of representative institutions by associating Indians with the lawmaking process. It thus provided that the Viceroy should nominate some Indians as non-official members of his expanded council. In 1862, Lord Canning, the then Viceroy, nominated 3 Indians to his legislative council, the Raja of Banaras, the Maharaja of Patiala and Sir Dinkar Rao. 2. It initiated the process of decentralization by restoring the legislative powers to the Bombay and Madras presidencies. It thus reversed the centralizing tendency that started from the Regulating Act of 1773 and reached its climax under the Charter Act of 1833. This policy of legislative devolution resulted in the grant of almost complete internal autonomy to the provinces in 1937. 3. It also provided for the establishment of new legislative councils for Bengal, Northwestern Frontier Province, NWFP, and Punjab, which were established in 1862, 1866 and 1897 respectively. 4. It empowered the Viceroy to make rules and orders for the more convenient transaction of business in the council. It also gave a recognition to the portfolio system, introduced by Lord Canning in 1859. Under this, a member of the Viceroy's council was made in charge of one or more departments of the government and was authorized to issue final orders on behalf of the council on matters of his department. 5. It empowered the Viceroy to issue ordinances, without the concurrence of the Legislative Council, during an emergency. The life of such an ordinance was 6 months. Features of the Act of 1892 1. It increased the number of additional, non-official, members in the central and provincial legislative councils, but maintained the official majority in them. 2. It increased the functions of legislative councils and gave them the power of discussing the budget. 5. And addressing questions to the executive. 3. It provided for the nomination of some non-official members of the Central Legislative Council by the Viceroy on the recommendation of the Provincial Legislative Councils and the Bengal Chamber of Commerce, and b. that of the Provincial Legislative Councils by the Governors on the recommendation of the district boards, municipalities, universities, trade associations, zemindars and chambers. The Act made a limited and indirect provision for the use of election in filling up some of the non-official seats both in the central and provincial legislative councils. The word election was, however, not used in the Act. The process was described as nomination made on the recommendation of certain bodies. 6. Features of the Act of 1909. This Act is also known as Morley Minto Reforms. Lord Morley was the then Secretary of State for India and Lord Minto was the then Viceroy of India. 1. It considerably increased the size of the legislative councils, both central and provincial. The number of members in the Central Legislative Council was raised from 16 to 60. The number of members in the provincial legislative councils was not uniform. 2. It retained official majority in the Central Legislative Council but allowed the provincial legislative councils to have non-official majority. 3. It enlarged the deliberative functions of the legislative councils at both the levels. For example, members were allowed to ask supplementary questions, move resolutions on the budget, and so on. 4. It provided, for the first time, for the association of Indians with the executive councils of the Viceroy and governors. Satyendra Prasad Sinha became the first Indian to join the Viceroy's Executive Council. He was appointed as the law member. 5. It introduced a system of communal representation for Muslims by accepting the concept of separate electorate. Under this, the Muslim members were to be elected only by Muslim voters. Thus, the Act legalized communalism, and Lord Minto came to be known as the father of communal electorate. 6. It also provided for the separate representation of presidency corporations, chambers of commerce, universities and zemindars. Government of India Act of 1919. On 20th August 1917, the British government declared, for the first time, that its objective was the gradual introduction of responsible government in India. 7. The Government of India Act of 1919 was thus enacted, which came into force in 1921. This act is also known as Montagu-Chelmsford Reforms. Montagu was the Secretary of State for India and Lord Chelmsford was the Viceroy of India. Features of the Act. 1. It relaxed the central control over the provinces by demarcating and separating the central and provincial subjects. The central and provincial legislatures were authorized to make laws on their respective list of subjects. However, the structure of government continued to be centralized and unitary. 2. It further divided the provincial subjects into two parts, transferred and reserved. The transferred subjects were to be administered by the governor with the aid of ministers responsible to the Legislative Council. The reserved subjects, on the other hand, were to be administered by the governor and his Executive Council without being responsible to the Legislative Council. This dual scheme of governance was known as diarchy, a term derived from the Greek word diarch, which means double rule. However, this experiment was largely unsuccessful. 3. It introduced, for the first time, bicameralism and direct elections in the country. Thus, the Indian Legislative Council was replaced by a bicameral legislature consisting of an upper house, Council of State, and a lower house, Legislative Assembly. The majority of members of both the houses were chosen by direct election. 4. It required that the 3 of the 6 members of the Viceroy's Executive Council, other than the Commander-in-Chief, were to be Indian. 5. It extended the principle of communal representation by providing separate electorates for 6 Indian Christians, Anglo-Indians and Europeans. 6. It granted franchise to a limited number of people on the basis of property, tax or education. 7. It created a new office of the High Commissioner for India in London and transferred to him some of the functions hitherto performed by the Secretary of State for India. 8. It provided for the establishment of a Public Service Commission. Hence, a Central Public Service Commission was set up in 1926 for recruiting civil servants. 8. 9. It separated, for the first time, provincial budgets from the central budget and authorized the provincial legislatures to enact their budgets. 10. It provided for the appointment of a statutory commission to inquire into and report on its working after 10 years of its coming into force. Salient Commission in November 1927 itself, i.e., 2 years before the schedule, the British government announced the appointment of a 7-member statutory commission under the chairmanship of Sir John Simon to report on the condition of India under its new constitution. All the members of the commission were British and hence, all the parties boycotted the commission. The commission submitted its report in 1930 and recommended the abolition of diarchy, extension of responsible government in the provinces, establishment of a federation of British India and princely states, continuation of communal electorate and so on. To consider the proposals of the Commission, the British government convened 3 round-table conferences of the representatives of the British government, British India and Indian princely states. On the basis of these discussions, a white paper on constitutional reforms was prepared and submitted for the consideration of the Joint Select Committee of the British Parliament. The recommendations of this committee were incorporated, with certain changes, in the next Government of India Act of 1935. Communal Award. In August 1932, Ramsay MacDonald, the British Prime Minister, announced a scheme of representation of the minorities, which came to be known as the Communal Award. The award not only continued separate electorates for the Muslims, Sikhs, Indian Christians, Anglo-Indians and Europeans but also extended it to the depressed classes, scheduled castes. Gandhiji was distressed over this extension of the principle of communal representation to the depressed classes and undertook fast unto death in Yevaka jail, Pune, to get the award modified. At last, there was an agreement between the leaders of the Congress and the depressed classes. The agreement, known as Pune Pact, retained the Hindu joint electorate and gave reserved seats to the depressed classes. Government of India Act of 1935. The Act marked a second milestone towards a completely responsible government in India. It was a lengthy and detailed document having 321 sections and 10 schedules. Features of the Act. 1. It provided for the establishment of an All India Federation consisting of provinces and princely states as units. The Act divided the powers between the centre and units in terms of 3 lists: Federal List, for centre, with 59 items, Provincial List, for provinces, with 54 items, and the Concurrent List, for both, with 36 items. Residuary powers were given to the Viceroy. However, the federation never came into being as the princely states did not join it. 2. It abolished diarchy in the provinces and introduced provincial autonomy in its place. The provinces were allowed to act as autonomous units of administration in their defined spheres. Moreover, the Act introduced responsible governments in provinces, that is, the governor was required to act with the advice of ministers responsible to the provincial legislature. This came into effect in 1937 and was discontinued in 1939. 3. It provided for the adoption of diarchy at the centre. Consequently, the federal subjects were divided into reserved subjects and transferred subjects. However, this provision of the Act did not come into operation at all. 4. It introduced bicameralism in 6 out of 11 provinces. Thus, the legislatures of Bengal, Bombay, Madras, Bihar, Assam and the United Provinces were made bicameral, consisting of a legislative council, upper house, and a legislative assembly, lower house. However, many restrictions were placed on them. 5. It further extended the principle of communal representation by providing separate electorates for depressed classes, scheduled castes, women and labor workers. 6. It abolished the Council of India, established by the Government of India Act of 1858. The Secretary of State for India was provided with a team of advisors. 7. It extended franchise. About 10% of the total population got the voting right. 8. It provided for the establishment of a Reserve Bank of India to control the currency and credit of the country. 9. It provided for the establishment of not only a Federal Public Service Commission but also a Provincial Public Service Commission and Joint Public Service Commission for 2 or more provinces. 10. It provided for the establishment of a Federal Court, which was set up in 1937. Indian Independence Act of 1947. On 20th February 1947, the British Prime Minister Clement Attlee declared that the British rule in India would end by 30th June 1948, after which the power would be transferred to responsible Indian hands. This announcement was followed by the agitation by the Muslim League demanding partition of the country. Again on 3rd June 1947, the British government made it clear that any constitution framed by the Constituent Assembly of India, formed in 1946, cannot apply to those parts of the country which were unwilling to accept it. On the same day, 3rd June 1947, Lord Mountbatten, the Viceroy of India, put forth the partition plan, known as the Mountbatten Plan. The plan was accepted by the Congress and the Muslim League. Immediate effect was given to the plan by enacting the Indian Independence Act 9, 1947. Features of the Act. 1. It ended the British rule in India and declared India as an independent and sovereign state from 15 August 1947. 2. It provided for the partition of India and creation of 2 independent dominions of India and Pakistan with the right to secede from the British Commonwealth. 3. It abolished the office of Viceroy and provided, for each dominion, a Governor-General, who was to be appointed by the British King on the advice of the Dominion Cabinet. His Majesty's government in Britain was to have no responsibility with respect to the government of India or Pakistan. 4. It empowered the constituent assemblies of the two dominions to frame and adopt any constitution for their respective nations and to repeal any act of the British Parliament, including the Independence Act itself. 5. It empowered the constituent assemblies of both the dominions to legislate for their respective territories till the new constitutions were drafted and enforced. No act of the British Parliament passed after 15 August 1947 was to extend to either of the new dominions unless it was extended thereto by a law of the legislature of the dominion.
6. It abolished
the office of the Secretary of State for India and transferred his functions to the Secretary of State for Commonwealth Affairs. 7. It proclaimed the lapse of British paramountcy over the Indian princely states and treaty relations with tribal areas from 15 August 1947. 8. It granted freedom to the Indian princely states either to join the Dominion of India or Dominion of Pakistan or to remain independent. 9. It provided for the governance of each of the dominions and the provinces by the Government of India Act of 1935, till the new constitutions were framed. The dominions were however authorized to make modifications in the Act. 10. It deprived the British monarch of his right to veto bills or ask for reservation of certain bills for his approval. But this right was reserved for the Governor-General. The Governor-General would have full power to assent to any bill in the name of His Majesty. 11. It designated the Governor-General of India and the provincial governors as constitutional, nominal, heads of the states. They were made to act on the advice of the respective Council of Ministers in all matters. 12. It dropped the title of Emperor of India from the royal titles of the King of England. 13. It discontinued the appointment to civil services and reservation of posts by the Secretary of State for India. The members of the civil services appointed before 15 August 1947 would continue to enjoy all benefits that they were entitled to till that time. At the stroke of midnight of 15 August 1947, the British rule came to an end and power was transferred to the two new independent dominions of India and Pakistan. 10. Lord Mountbatten became the first Governor-General of the new Dominion of India. He swore in Jawaharlal Nehru as the first Prime Minister of independent India. The Constituent Assembly of India formed in 1946 became the Parliament of the Indian Dominion. Table 1.1 Interim Government, 1946.
1.
1. Jawaharlal Nehru External Affairs and Commonwealth Relations. 2. Sardar Vallabhbhai Patel Home, Information and Broadcasting. 3. Dr. Rajendra Prasad Food and Agriculture. 4. Dr. John Mathai Industries and Supplies. 5. Jagjeevan Ram Labour. 6. Sardar Baldev Singh Defence. 7. C.H. Bhabha Works, Mines and Power. 8. Liaquat Ali Khan Finance. 9. Abdur Rab Nishtar Posts and Air. 10. Asaf Ali Railways and Transport. 11. C. Rajgopalachari Education and Arts. 12. II Chundarigar Commerce. 13. Janpur Ali Khan Health. 14. Joginder Nath Mandal Law. Note: the members of the interim government were members of the Viceroy's Executive Council. The Viceroy continued to be the head of the council. But Jawaharlal Nehru was designated as the Vice President of the council. Table 1.2 First Cabinet of Free India, 1947, SL No. Members Portfolios held. 1. Jawaharlal Nehru Prime Minister, External Affairs and Commonwealth Relations, Scientific Research Sardar.
2.
Vallabhbhai Home, Information and Broadcasting, States Patel. 3. Dr. Rajendra Prasad Food and Agriculture. 4. Maulana Abul Kalam Azad Education. 5. Dr. John Mathai Railways and Transport. 6. R.K. Shanmugam Chaitya Finance. 7. Dr. B.R. Ambedkar Law. 8. Jagjeevan Ram Labour. 9. Sardar Baldev Singh Defence. 10. Rajkumari Amrit Kaur Health. 11. C.H. Bhabha Commerce. 12. Rafi Ahmed Kidwai Communication. 13. Dr. Shyam Prasad Mukherjee Industries and Supplies. 14. D.N. Gadgil Works, Mines and Power. Notes and References. 1. The Mughal Emperor, Shah Alam, granted Diwani to the company after its victory in the Battle of Buxar, 1764. Two, it was
Introduced in the
British Parliament by the then Prime Minister, William Pitt.
3.
At that time, the civil services of the company were classified into covenanted civil services, higher civil services, and uncovenanted civil services, lower civil services. The former was created by a law of the company, while the latter was created otherwise. 4. Subhash C. Kashyap, Our Constitution, National Book Trust, 3rd edition, 2001, p. 14. 5. The system of budget was introduced in British India in 1860. 6. V. N. Shukla, The Constitution of India, Eastern Book Company, 10th edition, 2001, p. 10. 7. The declaration thus stated, the policy of His Majesty's government is that of the increasing association of Indians in every branch of the administration, and the gradual development of self-government institutions, with a view to the progressive realization of responsible government in India as an integral part of the British Empire. 8. This was done on the recommendation of the Lee Commission on Superior Civil Services in India, 1923-24. 9. The Indian Independence Bill was introduced in the British Parliament on 4 July 1947 and received the royal assent on 18 July 1947. The Act came into force on 15 August 1947. 10. The boundaries between the two dominions were determined by a boundary commission headed by Radcliffe. Pakistan included the provinces of West Punjab, Sindh, Baluchistan, East Bengal, Northwestern Frontier Province and the district of Sylhet in Assam. The referendum in the Northwestern Frontier Province and Sylhet was in favor of Pakistan.
Making of the Constitution demand for Constituent Assembly. It was in 1934 that the idea of a Constituent Assembly for India was put forward for the first time by M.N. Roy, a pioneer of communist movement in India. In 1935, the Indian National Congress, INC, for the first time, officially demanded a Constituent Assembly to frame the Constitution of India. In 1938, Jawaharlal Nehru, on behalf of the INC, declared that the Constitution of Free India must be framed, without outside interference, by a Constituent Assembly elected on the basis of adult franchise. The demand was finally accepted in principle by the British government in what is known as the August Offer of 1940. In 1942, Sir Stafford Cripps, a member of the cabinet, came to India with the draft proposal of the British government on the framing of an independent constitution to be adopted after the World War II. The Cripps proposals were rejected by the Muslim League, which wanted India to be divided into two autonomous states with two separate constituent assemblies. Finally, a cabinet mission was sent to India. While it rejected the idea of two constituent assemblies, it put forth a scheme for the Constituent Assembly which more or less satisfied the Muslim League. Composition of the Constituent Assembly.
The Constituent Assembly was constituted in November 1946 under the scheme formulated by the Cabinet Mission Plan. The features of the scheme were: 1. The total strength of the Constituent Assembly was to be 389. Of these, 296 seats were to be allotted to British India and 93 seats to the princely states. Out of 296 seats allotted to the British India, 292 members were to be drawn from the 11 governors' provinces 2 and 4 from the 4 chief commissioners' provinces 3, 1 from each. To each province and princely state, or group of states in case of small states, were to be allotted seats in proportion to their respective population. Roughly, 1 seat was to be allotted for every million population. 3 seats allocated to each British province were to be divided among the 3 principal communities, Muslims, Sikhs and general, all except Muslims and Sikhs, in proportion to their population. 4. The representatives of each community were to be elected by members of that community in the provincial legislative assembly, and voting was to be by the method of proportional representation by means of single transferable vote. 5. The representatives of princely states were to be nominated by the heads of the princely states. It is thus clear that the Constituent Assembly was to be a partly elected and partly nominated body. Moreover, the members were to be indirectly elected by the members of the provincial assemblies, who themselves were elected on a limited franchise. 4. The elections to the Constituent Assembly, for 296 seats allotted to the British Indian provinces, were held in July-August 1946. The Indian National Congress won 208 seats, the Muslim League 73 seats, and the small groups and independents got the remaining 15 seats. However, the 93 seats allotted to the princely states were not filled as they decided to stay away from the Constituent Assembly. Although the Constituent Assembly was not directly elected by the people of India on the basis of adult franchise, the Assembly comprised representatives of all sections of Indian society: Hindus, Muslims, Sikhs, Parsis, Anglo-Indians, Indian Christians, SCs, STs including women of all
these sections.
The Assembly included all important personalities of India at that time, with the exception of Mahatma Gandhi. Working of the Constituent Assembly. The Constituent Assembly held its first meeting on 9 December 1946. The Muslim League boycotted the meeting and insisted on a separate state of Pakistan. The meeting was thus attended by only 211 members. Dr. Satchidanand Sinha, the oldest member, was elected as the temporary president of the Assembly, following the French practice. Later, Dr. Rajendra Prasad was elected as the president of the Assembly. Similarly, both H.C. Mukherjee and V.T. Krishnamachari were elected as the vice presidents of the Assembly. In other words, the Assembly had two vice presidents. Objectives Resolution. On 13 December 1946, Jawaharlal Nehru moved the historic Objectives Resolution in the Assembly. It laid down the fundamentals and philosophy of the constitutional structure. It read: 1. This Constituent Assembly declares its firm and solemn resolve to proclaim India as an independent sovereign republic and to draw up for her future governance a constitution, 2. Wherein the territories that now comprise British India, the territories that now form the Indian states, and such other parts of India as are outside India, and the states as well as other territories as are willing to be constituted into the independent sovereign India, shall be a union of them all, and 3. Wherein the said territories, whether with their present boundaries or with such others as may be determined by the Constituent Assembly and thereafter according to the law of the Constitution, shall possess and retain the status of autonomous units together with residuary powers and exercise all powers and functions of government and administration save and except such powers and functions as are vested in or assigned to the Union or as are inherent or implied in the Union or resulting therefrom. And 4. Wherein all power and authority of the sovereign independent India, its constituent parts and organs of government are derived from the people, and 5. Wherein shall be guaranteed and secured to all the people of India justice, social, economic and political, equality of status of opportunity, and before the law, freedom of thought, expression, belief, faith, worship, vocation, association and action, subject to law and public morality, and 6. Wherein adequate safeguards shall be provided for minorities, backward and tribal areas, and depressed and other backward classes, and 7. Whereby shall be maintained the integrity of the territory of the Republic and its sovereign rights on land, sea and air according to justice and the law of civilized nations, and 8. This ancient land attains its rightful and honored place in the world and makes its full and willing contribution to the promotion of world peace and the welfare of mankind. This resolution was unanimously adopted by the Assembly on 22 January 1947. It influenced the eventual shaping of the Constitution through all its subsequent stages. Its modified version forms the preamble of the present Constitution. Changes by the Independence Act. The representatives of the princely states, who had stayed away from the Constituent Assembly, gradually joined it. On 28 April 1947, representatives of the 6 states 5 were part of the Assembly. After the acceptance of the Mountbatten Plan of 3 June 1947 for a partition of the country, the representatives of most of the other princely states took their seats in the Assembly. The members of the Muslim League from the Indian Dominion also entered the Assembly. The Indian Independence Act of 1947 made the following 3 changes in the position of the Assembly. 1. The Assembly was made a fully sovereign body, which could frame any constitution it pleased. The Act empowered the Assembly to abrogate or alter any law made by the British Parliament in relation to India.
2. The Assembly also became a legislative body.
In other words, 2 separate functions were assigned to the Assembly, that is, making of a constitution for free India and enacting of ordinary laws for the country. These 2 tasks were to be performed on separate days. Thus, the Assembly became the first Parliament of Free India, Dominion legislature. Whenever the Assembly met as the constituent body, it was chaired by Dr. Rajendra Prasad, and when it met as the legislative body 6, it was chaired by G.V. Madlankar. These 2 functions continued till 26 November 1949, when the task of making the constitution was over. 3. The Muslim League members, hailing from the areas 7 included in the Pakistan, withdrew from the Constituent Assembly for India. Consequently, the total strength of the Assembly came down to 299 as against 389 originally fixed in 1946 under the Cabinet Mission Plan. The strength of the Indian provinces, formerly British provinces, was reduced from 296 to 229, and those of the princely states from 93 to 70. The state-wise membership of the Assembly as on 31 December 1947 is shown in Table 2.4 at the end of this chapter. Other functions performed in addition to the making of the Constitution and enacting of ordinary laws. The Constituent Assembly also performed the following functions. 1. It ratified the India's membership of the Commonwealth in May 1949. 2. It adopted the national flag on 22 July 1947. 3. It adopted the national anthem on 24 January 1950. 4. It adopted the national song on 24 January 1950. 5. It elected Dr. Rajendra Prasad as the first President of India on 24 January 1950. In all, the Constituent Assembly had 11 sessions over 2 years, 11 months and 18 days. The constitution makers had gone through the constitutions of about 60 countries, and the draft constitution was considered for 114 days. The total expenditure incurred on making the constitution amounted to 64 lakh. On 24 January 1950, the Constituent Assembly held its final session. It, however, did not end, and continued as the Provisional Parliament of India. From 26 January 1950 till the formation of new Parliament 8 after the first general elections in 1951-52. Committees of the Constituent Assembly. The Constituent Assembly appointed a number of committees to deal with different tasks of constitution making. Out of these, 8 were major committees and the others were minor committees. The names of these committees and their chairmen are given below. Major committees: 1. Union Powers Committee Jawaharlal Nehru. 2. Union Constitution Committee Jawaharlal Nehru. 3. Provincial Constitution Committee Sardar Patel. 4. Drafting Committee Dr. B.R. Ambedkar. 5. Advisory Committee on Fundamental Rights, Minorities and Tribal and Excluded Areas Sardar Patel. This committee had the following 5 subcommittees: A. Fundamental Rights Subcommittee J.B. Kripalani. B. Minorities Subcommittee H.C. Mukherjee. C. Northeast Frontier Tribal Areas and Assam Excluded and Partially Excluded Areas Subcommittee Gopinath Bardoloi. D. Excluded and Partially Excluded Areas, other than those in Assam, Subcommittee A.V. Thakur. E. Northwest Frontier Tribal Areas Subcommittee 8-6. Rules of Procedure Committee Dr. Rajendra Prasad. 7. States Committee, Committee for Negotiating with States, Jawaharlal Nehru 8. Steering Committee Dr. Rajendra Prasad. Minor Committees 1. Finance and Staff Committee Dr. Rajendra Prasad 2. Credentials Committee Alladi Krishnaswamy Iyer 3. House Committee V. Pattabi Sitaramaya. For Order of Business Committee Dr. K.M. Munshi 5. Ad Hoc Committee on the National Flag Dr. Rajendra Prasad 6. Committee on the Functions of the Constituent Assembly G.V. Mavlankar 7. Ad Hoc Committee on the Supreme Court S. Vardachari, not an Assembly member, 8. Committee on Chief Commissioners Provinces B. Pattabi Sitaramaya 9. Expert Committee on the Financial Provisions of the Union Constitution Nalini Ranjan Sarkar, not an Assembly member, 10. Linguistic Provinces Commission S. Kedar, not an Assembly member, 11. Special Committee to examine the draft Constitution Jawaharlal Nehru 12. Press Gallery Committee Usha Nath Sen 13. Ad Hoc Committee on Citizenship S. Vardachari. Drafting Committee. Among all the committees of the Constituent Assembly, the most important committee was the Drafting Committee set up on 29 August 1947. It was this committee that was entrusted with the task of preparing a draft of the new constitution. It consisted of 7 members. They were 1. Dr. B.R. Ambedkar, Chairman, 2. N. Gopalaswamy Iyengar 3. Alladi Krishnaswamy Iyer 4. Dr. K.M. Munshi 5. Syed Mohammad Sadullah 6. N. Madhava Roy, he replaced B.L. Mitta who resigned due to ill health, 7. T.T. Krishnamachari, he replaced D.P. Khaitan who died in 1948. The Drafting Committee, after taking into consideration the proposals of the various committees, prepared the first draft of the Constitution of India, which was published in February 1948. The people of India were given 8 months to discuss the draft and propose amendments. In the light of the public comments, criticisms and suggestions, the Drafting Committee prepared a second draft, which was published in October 1948. The Drafting Committee took less than 6 months to prepare its draft. In all, it sat only for 141 days. Enactment of the Constitution. Dr. B.R. Ambedkar introduced the final draft of the Constitution in the Assembly on 4 November 1948, first reading. The Assembly had a general discussion on it for 5 days, till 9 November 1948. The second reading, clause by clause consideration, started on 15 November 1948 and ended on 17 October 1949. During this stage, as many as 7,653 amendments were proposed and 2,473 were actually discussed in the Assembly. The third reading of the draft started on 14 November 1949. Dr. B.R. Ambedkar moved a motion, the Constitution as settled by the Assembly be passed. The motion on draft Constitution was declared as passed on 26 November 1949, and received the signatures of the members and the President. Out of a total 299 members of the Assembly, only 284 were actually present on that day and signed the Constitution. This is also the date mentioned in the Preamble as the date on which the people of India in the Constituent Assembly adopted, enacted and gave to themselves this Constitution. The Constitution as adopted on 26 November 1949, contained a preamble, 395 articles and 8 schedules. The preamble was enacted after the entire Constitution was already enacted. Dr. B.R. Ambedkar, the then Law Minister, piloted the draft Constitution in the Assembly. He took a very prominent part in the deliberations of the Assembly. He was known for his logical, forceful and persuasive arguments on the floor of the Assembly. He is recognized as the father of the Constitution of India. This brilliant writer, constitutional expert, undisputed leader of the scheduled castes and the chief architect of the Constitution of India, is also known as a modern Manu. Enforcement of the Constitution. Some provisions of the Constitution pertaining to citizenship, elections, provisional parliament, temporary and transitional provisions, and short title.
contained in Articles 5,
6, 7, 8, 9, 60, 324, 366, 367, 379, 380, 388, 391, 392 and 393 came into force on 26 November 1949 itself. The remaining provisions, the major part, of the Constitution came into force on 26 January 1950. This day is referred to in the Constitution as the date of its commencement, and celebrated as the Republic Day. January 26 was specifically chosen as the date of commencement of the Constitution because of its historical importance. It was on this day in 1930 that Purna Swaraj Day was celebrated, following the resolution of the Lahore session, December 1929, of the INC. With the commencement of the Constitution, the Indian Independence Act of 1947 and the Government of India Act of 1935, with all enactments amending or supplementing the latter act, were repealed. The abolition of Privy Council Jurisdiction Act, 1949, was however continued. Criticism of the Constituent Assembly. The critics have criticized the Constituent Assembly on various grounds. These are as follows. 1. Not a representative body. The critics have argued that the Constituent Assembly was not a representative body as its members were not directly elected by the people of India on the basis of universal adult franchise. 2. Not a sovereign body. The critics maintained that the Constituent Assembly was not a sovereign body as it was created by the proposals of the British government. Further, they said that the Assembly held its sessions with the permission of the British government. 3. Time consuming. According to the critics, the Constituent Assembly took unduly long time to make the Constitution. They stated that the framers of the American Constitution took only 4 months to complete their work. In this context, Naziruddin Ahmed, a member of the Constituent Assembly, coined a new name for the drafting committee to show his contempt for it. He called it a drifting committee. 4. Dominated by Congress. The critics charged that the Constituent Assembly was dominated by the Congress Party. Granville Austin, a British constitutional expert, remarked, "The Constituent Assembly was a one-party body in an essentially one-party country. The Assembly was the Congress and the Congress was India 9. 5. Lawyer-politician domination. It is also maintained by the critics that the Constituent Assembly was dominated by lawyers and politicians. They pointed out that other sections of the society were not sufficiently represented. This, to them, is the main reason for the bulkiness and complicated language of the Constitution. 6. Dominated by Hindus. According to some critics, the Constituent Assembly was a Hindu-dominated body. Lord Viscount Simon called it a body of Hindus. Similarly, Winston Churchill commented that the Constituent Assembly represented only one major community in India. Important facts. 1. Elephant was adopted as the symbol, seal, of the Constituent Assembly. 2. Sir B.N. Roy was appointed as the constitutional advisor, legal advisor, to the Constituent Assembly. 3. H.B.R. Iyengar was the secretary to the Constituent Assembly. 4. S.N. Mukherjee was the chief draftsman of the Constitution in the Constituent Assembly. 5. Prem Bihari Narayan Rijada was the calligrapher of the Indian Constitution. The original Constitution was handwritten by him in a flowing italic style. 6. The original version was beautified and decorated by artists from Shantiniketan including Nand Lal Bose and Biohar Ram Manohar Sinha. 7. Biohar Ram Manohar Sinha illuminated, beautified and ornamented the original preamble calligraphed by Prem Bihari Narayan Rijada. 8. The calligraphy of the Hindi version of the original Constitution was done by Vasant Krishan Vedya and elegantly decorated and illuminated by Nand Lal Bose. Table 2.1 Allocation of seats in the Constituent Assembly of India, 1946, SL.No. Areas Seats 1. British Indian Provinces, 11, 292 2. Princely States, Indian States, 93.
3 Chief Commissioners Provinces, 4.
4 total 389 Table 2.2 Results of the elections to the Constituent Assembly, July-August 1946, SL.No. Name of the party seats 1-1. Congress 208-2. Muslim League 73-3. Unionist Party 1-4. Unionist Muslims 1-5. Unionist Scheduled Castes 1-6. Krishak Praja Party 1-7. Scheduled Castes Federation 1-8. 6. Non-Congress 1-9. Communist Party 1-10. Independents 8 total 296 Table 2.3 Community-wise representation in the Constituent Assembly, 1946, SL.No. Community strength 1. Hindus 163-2. Muslims 83. Scheduled castes 31-4. Indian Christians 6. 5 backward tribes 6-6. 6-4-7. Anglo-Indians 3-8. Parsas 3 total 296 Table 2.4 Stateways membership of the Constituent Assembly of India as on 31st December 1947 S.No. Name no of members A provinces, Indian provinces, 2291. Madras 49-2. Bombay 21-3. West Bengal 19-4. United Provinces 55-5. East Punjab 12-6. Bihar 36-7. CP and Beira 17-8. Assam 8-9. Odisha 9-10. Delhi 1-11. Ajmer Mewara 1-12. Cool 1B Indian States, Princely States, 71. Alwar 1. 2 Baroda 3-3. Bhopal 1-4. Bikaner 1-5. Cochin 1-6. Gwalior 4-7. Indore 1-8. Jaipur 3-9. Jodhpur 2-10. Kolhapur 1-11. Kota 1-12. Mayurbhanj 1-13. Mysore 7-14. Patiala 2-15. Rewa 2-16. Travancore 6-17. Udaipur 2-18. Sikkim and Cooch Behar Group 1-19. Tripura, Manipur and Khasi States Group 1-20. UP States Group 1-21. Eastern Rajputana States Group 3-22. Central India States Group, including Bundelkhand and Malwa, 3-23. Western India States Group 4-24. Gujarat States Group 2. 25 Deccan and Madras States Group 2-26. Punjab States Group 3-27. Eastern States Group by 4-28. Eastern States Group 2 3-29. Residuary States Group 4 total 299 Table 2.5 Sessions of the Constituent Assembly at a glance. Sessions period. First session 9-23 December 1946. Second session 20-25 January 1947. Third session 28 April to May 1947. Fourth session 14-31 July 1947. Fifth session 14-30 August 1947. Sixth session 27th January 1948. Seventh session 4th November 1948 January 1949. Eighth session 16 May 16 June 1949. Ninth session 30 July 18 September 1949. 10th session 6-17 October 1949. 11th session 14-26 November 1949. Note: the Assembly met once again on 24 January 1950, when the members appended their signatures to the Constitution of India. Notes and references. 1. The Cabinet Mission, consisting of 3 members, Lord Pethick Lawrence, Sir Stafford Cripps and A.V. Alexander, arrived in India on 24 March 1946. The Cabinet Mission published its plan on 16 May 1946. 2. These include Madras, Bombay, UP, Bihar, Central Provinces, Orissa, Punjab, NWFP, Sindh, Bengal and Assam. 3. These include Delhi, Ajmer Mewara, Cool and British Baluchistan. 4. The Government of India Act of 1935 granted limited franchise on the basis of tax, property and education. 5 these include Baroda, Bikaner, Jaipur, Patiala, Rewa and Udaipur. 6 For the first time, the Constituent Assembly met as Dominion Legislature on 17 November 1947 and elected G.V. Madlankar as its Speaker. 7 These are West Punjab, East Bengal, NWFP, Sindh, Baluchistan and Sylhet district of Assam. A separate Constituent Assembly was set up for Pakistan. 8 The Provisional Parliament ceased to exist on 17 April 1952. The first elected parliament with the 2 houses came into being in May 1952. 8a One of the political consequences of the British government's statement of 3 June 1947 was that following a referendum, the Northwest Frontier Province and Baluchistan became part of the territory of the Dominion of Pakistan, and as a result the tribal areas in this region became a concern of that Dominion. The subcommittee on the tribal areas in the Northwest Frontier Province and Baluchistan was not therefore called upon to function on behalf of the Constituent Assembly of India. B. Shiva Rao, The Framing of India's Constitution, Select Documents, Volume 3, p. 681. The members of this subcommittee were Khan Abdul Ghaffar Khan, Khan Abdul Samad Khan and Meher Chand Khanna. The information about the chairman is not found. 9 Granville Austin, The Indian Constitution, Cornerstone of a Nation, Oxford, 1966, p. 8.
Salient features of the Constitution. Introduction.
The Indian Constitution is unique in its contents and spirit. Though borrowed from almost every constitution of the world, the Constitution of India has several salient features that distinguish it from the constitutions of other countries. It should be noted at the outset that a number of original features of the Constitution, as adopted in 1949, have undergone a substantial change, on account of several amendments, particularly 7th, 42nd, 44th, 73rd, 74th and 97th Amendments. In fact, the 42nd Amendment Act, 1976, is known as Mini-Constitution, due to the important and large number of changes made by it in various parts of the Constitution. However, in the Keswananda Vaki Case 1, 1973, the Supreme Court ruled that the constituent power of Parliament under Article 368 does not enable it to alter the basic structure of the Constitution. Salient features of the Constitution. The salient features of the Constitution, as it stands today, are as follows. 1. Lengthiest written Constitution. Constitutions are classified into written, like the American Constitution, or unwritten, like the British Constitution. The Constitution of India is the lengthiest of all the written constitutions of the world. It is a very comprehensive, elaborate and detailed document. Originally, 1949, the Constitution contained a preamble, 395 articles, divided into 22 parts, and 8 schedules. Presently, 2016, it consists of a preamble, about 465 articles, divided into 25 parts, and 12 schedules too. The various amendments carried out since 1951 have deleted about 20 articles and 1 part, 7, and added about 90 articles, 4 parts, IVA, IXA, IXB and XIVA, and 4 schedules, 9, 10, 11 and 12. No other constitution in the world has so many articles and schedules. 3. 4 factors have contributed to the elephantine size of our constitution. They are a. Geographical factors, that is, the vastness of the country and its diversity. B. Historical factors, e.g., the influence of the Government of India Act of 1935, which was bulky. C. Single constitution for both the centre and the states except Jammu and Kashmir. 4. D. Dominance of legal luminaries in the Constituent Assembly. The Constitution contains not only the fundamental principles of governance but also detailed administrative provisions. Further, those matters which in other modern democratic countries have been left to the ordinary legislation or established political conventions have also been included in the constitutional document itself in India. To drawing from various sources, the Constitution of India has borrowed most of its provisions from the constitutions of various other countries as well as from the Government of India Act 5 of 1935. Dr. B.R. Ambedkar proudly acclaimed that the Constitution of India has been framed after ransacking all the known constitutions of the world. 6. The structural part of the Constitution is, to a large extent, derived from the Government of India Act of 1935. The philosophical part of the Constitution. The fundamental rights and the directive principles of state policy derive their inspiration from the American and Irish constitutions respectively. The political part of the Constitution, the principle of cabinet government and the relations between the executive and the legislature, have been largely drawn from the British Constitution. 7. The other provisions of the Constitution have been drawn from the constitutions of Canada, Australia, Germany, USSR, now Russia, France, South Africa, Japan, and so on. 8. The most profound influence and material source of the Constitution is the Government of India Act, 1935. The federal scheme, judiciary, governors, emergency powers, the public service commissions and most of the administrative details are drawn from this act. More than half of the provisions of Constitution are identical to or bear a close resemblance to the Act of 19,359. 3. Blend of rigidity and flexibility. Constitutions are also classified into rigid and flexible. A rigid constitution is one that requires a special procedure for its amendment, as for example, the American Constitution. A flexible constitution, on the other hand, is one that can be amended in the same manner as the ordinary laws are made, as for example, the British Constitution. The Constitution of India is neither rigid nor flexible but a synthesis of both. Article 368 provides for two types of amendments. A. Some provisions can be amended by a special majority of the Parliament, i.e., a two-third majority of the members of each house present and voting, and a majority, that is, more than 50%, of the total membership of each house. B. Some other provisions can be amended by a special majority of the Parliament and with the ratification by half of the total states. At the same time, some provisions of the Constitution can be amended by a simple majority of the Parliament in the manner of ordinary legislative process. Notably, these amendments do not come under Article 368. 4. Federal system with unitary bias. The Constitution of India establishes a federal system of government. It contains all the usual features of a federation, viz. 2. Government, division of powers, written constitution, supremacy of constitution, rigidity of constitution, independent judiciary and bicameralism. However, the Indian Constitution also contains a large number of unitary or non-federal features, viz. A strong center, single constitution, single citizenship, flexibility of constitution, integrated judiciary, appointment of state governor by the center, all India services, emergency provisions, and so on. Moreover, the term federation has nowhere been used in the Constitution. Article 1, on the other hand, describes India as a union of states, which implies two things. 1. Indian federation is not the result of an agreement by the states, and 2. No state has the right to secede from the federation. Hence, the Indian Constitution has been variously described as federal in form but unitary in spirit, quasi-federal, by K.C. Weir, bargaining federalism, by Morris Jones, cooperative federalism, by Granville Austin, federation with a centralizing tendency, by Ivor Jennings, and so on. 5. Parliamentary form of government. The Constitution of India has opted for the British parliamentary system of government rather than American presidential system of government. The parliamentary system is based on the principle of cooperation and coordination between the legislative and executive organs, while the presidential system is based on the doctrine of separation of powers between the two organs. The parliamentary system is also known as the Westminster 10 model of government, responsible government and cabinet government. The Constitution establishes the parliamentary system not only at the centre but also in the states. The features of parliamentary government in India: A. Presence of nominal and real executives. B. Majority party rule. C. Collective responsibility of the executive to the legislature. D. Membership of the ministers in the legislature. E. Leadership of the prime minister or the chief minister. F. Dissolution of the lower house, Lok Sabha or assembly. Even though the Indian parliamentary system is largely based on the British pattern, there are some fundamental differences between the two. For example, the Indian Parliament is not a sovereign body like the British Parliament. Further, the Indian state has an elected head, republic, while the British state has hereditary head, monarchy. In a parliamentary system, whether in India or Britain, the role of the Prime Minister has become so significant and crucial that the political scientists like to call it a prime ministerial government. 6. Synthesis of parliamentary sovereignty and judicial supremacy. The doctrine of sovereignty of parliament is associated with the British Parliament, while the principle of judicial supremacy with that of the American Supreme Court. Just as the Indian parliamentary system differs from the British system, the scope of judicial review power of the Supreme Court in India is narrower than that of what exists in US. This is because the American Constitution provides for due process of law, against that of procedure established by law, contained in the Indian Constitution, Article 21. Therefore, the framers of the Indian Constitution have preferred a proper synthesis between the British principle of parliamentary sovereignty and the American principle of judicial supremacy. The Supreme Court, on the one hand, can declare the parliamentary laws as unconstitutional through its power of judicial review. The Parliament, on the other hand, can amend the major portion of the Constitution through its constituent power. 7. Integrated and independent judiciary. The Indian Constitution establishes a judicial system that is integrated as well as independent. The Supreme Court stands at the top of the integrated judicial system in the country. Below it, there are high courts at the state level. Under a high court, there is a hierarchy of subordinate courts, that is, district courts and other lower courts. This single system of courts enforces both the central laws as well as the state laws, unlike in USA, where the federal laws are enforced by the federal judiciary and the state laws are enforced by the state judiciary. The Supreme Court is a federal court, the highest court of appeal, the guarantor of the fundamental rights of the citizens and the guardian of the Constitution. Hence, the Constitution has made various provisions to ensure its independence, security of tenure of the judges, fixed service conditions for the judges, all the expenses of the Supreme Court charged on the Consolidated Fund of India, prohibition on discussion on the conduct of judges in the legislatures, ban on practice after retirement, power to punish for its contempt vested in the Supreme Court, separation of the judiciary from the executive, and so on. 8. Fundamental Rights. Part 3 of the Indian Constitution guarantees 11 fundamental rights to all the citizens. A. Right to equality, Articles 14-18. B. Right to freedom, Articles 19-22. C. Right against exploitation, Articles 23-24. D. Right to freedom of religion, Articles 25-28. E. Cultural and educational rights, Articles 29-30. And F. Right to constitutional remedies, Article 32. The fundamental rights are meant for promoting the idea of political democracy. They operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. They are justiciable in nature, that is, they are enforceable by the courts for their violation. The aggrieved person can directly go to the Supreme Court, which can issue the writs of habeas corpus, mandamus, prohibition, certiorari and quo warranto for the restoration of his rights. However, the fundamental rights are not absolute and subject to reasonable restrictions. Further, they are not sacrosanct and can be curtailed.
Or repealed by the Parliament
through a Constitutional Amendment Act. They can also be suspended during the operation of a national emergency except the rights guaranteed by Articles 20 and 21. 9. Directive Principles of State Policy. According to Dr. B.R. Ambedkar, the Directive Principles of State Policy is a novel feature of the Indian Constitution. They are enumerated in Part 4 of the Constitution. They can be classified into 3 broad categories: socialistic, Gandhian and liberal intellectual. The directive principles are meant for promoting the ideal of social and economic democracy. They seek to establish a welfare state in India. However, unlike the fundamental rights, the directives are non-justiciable in nature, that is, they are not enforceable by the courts for their violation. Yet, the Constitution itself declares that these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Hence, they impose a moral obligation on the state authorities for their application. But the real force, sanction, behind them is political, that is, public opinion. In the Minerva Mills Case 12, 1980, the Supreme Court held that the Indian Constitution is founded on the bedrock of the balance between the fundamental rights and the directive principles. 10 fundamental duties. The original Constitution did not provide for the fundamental duties of the citizens. These were added during the operation of internal emergency, 1975-77, by the 42nd Constitutional Amendment Act of 1976 on the recommendation of the Swan Singh Committee. The 86th Constitutional Amendment Act of 2002 added one more fundamental duty. The Part 4A of the Constitution, which consists of only one article, 51A, specifies the 11 fundamental duties, viz. To respect the Constitution, national flag and national anthem, to protect the sovereignty, unity and integrity of the country, to promote the spirit of common brotherhood amongst all the people, to preserve the rich heritage of our composite culture, and so on. The fundamental duties serve as a reminder to citizens that while enjoying their rights, they have also to be quite conscious of duties they owe to their country, their society and to their fellow citizens. However, like the directive principles, the duties are also non-justiciable in nature. 11. A secular state. The Constitution of India stands for a secular state. Hence, it does not uphold any particular religion as the official religion of the Indian state. The following provisions of the Constitution reveal the secular character of the Indian state. The term secular was added to the preamble of the Indian Constitution by the 42nd Constitutional Amendment Act of 1976. B. The preamble secures to all citizens of India liberty of belief, faith and worship. C. The state shall not deny to any person equality before the law or equal protection of the laws. Article 14. D. The state shall not discriminate against any citizen on the ground of religion. Article 15. E. Equality of opportunity for all citizens in matters of public employment. Article 16. F. All persons are equally entitled to freedom of conscience and the right to freely profess, practice and propagate any religion. Article 25. G. Every religious denomination or any of its sections shall have the right to manage its religious affairs. Article 26. H. No person shall be compelled to pay any taxes for the promotion of a particular religion. Article 27. I. No religious instruction shall be provided in any educational institution maintained by the state. Article 28. J. Any section of the citizens shall have the right to conserve its distinct language, script or culture. Article 29. K. All minorities shall have the right to establish and administer educational institutions of their choice. Article 30. L. The state shall endeavor to secure for all the citizens a uniform civil code. Article 44. The Western concept of secularism connotes a complete separation between the religion, the church, and the state, the politics. This negative concept of secularism is inapplicable in the Indian situation where the society is multi-religious. Hence, The Indian Constitution embodies the positive concept of secularism, i.e., giving equal respect to all religions or protecting all religions equally. Moreover, the Constitution has also abolished the old system of communal representation 13, that is, reservation of seats in the legislatures on the basis of religion. However, it provides for the temporary reservation of seats for the scheduled castes and scheduled tribes to ensure adequate representation to them. 12. Universal adult franchise. The Indian Constitution adopts universal adult franchise as a basis of elections to the Lok Sabha and the state legislative assemblies. Every citizen who is not less than 18 years of age has a right to vote without any discrimination of caste, race, religion, sex, literacy, wealth, and so on. The voting age was reduced to 18 years from 21 years in 1989 by the 61st Constitutional Amendment Act of 1988. The introduction of universal adult franchise by the constitution makers was a bold experiment and highly remarkable in view of the vast size of the country, its huge population, high poverty, social inequality and overwhelming illiteracy. 14. Universal adult franchise makes democracy broad-based, enhances the self-respect and prestige of the common people, upholds the principle of equality, enables minorities to protect their interests and opens up new hopes and vistas for weaker sections. 13. Single citizenship. Though the Indian Constitution is federal and envisages a dual polity, centre and states, it provides for only a single citizenship, that is, the Indian citizenship. In countries like USA, on the other hand, each person is not only a citizen of USA but also a citizen of the particular state to which he belongs. Thus, he owes allegiance to both and enjoys dual sets of rights, one conferred by the national government and another by the state government. In India, all citizens irrespective of the state in which they are born or reside enjoy the same political and civil rights of citizenship all over the country, and no discrimination is made between them excepting in few cases like tribal areas, Jammu and Kashmir, and so on. Despite the constitutional provision for a single citizenship and uniform rights for all the people, India has been witnessing the communal riots, class conflicts, caste wars, linguistic clashes and ethnic disputes. This means that the cherished goal of the constitution makers to build an united and integrated Indian nation has not been fully realized. 14. Independent bodies. The Indian Constitution not only provides for the legislative, executive and judicial organs of the government, central and state, but also establishes certain independent bodies. They are envisaged by the Constitution as the bulwarks of the democratic system of government in India. These are a. Election Commission to ensure free and fair elections to the Parliament, the state legislatures, the Office of President of India and the Office of Vice President of India. B. Controller and Auditor General of India to audit the accounts of the central and state governments. He acts as the guardian of public purse and comments on the legality and propriety of government expenditure. C. Union Public Service Commission to conduct examinations for recruitment to all India services 15 and higher central services and to advise the President on disciplinary matters. D. State Public Service Commission in every state to conduct examinations for recruitment to state services and to advise the Governor on disciplinary matters. The Constitution ensures the independence of these bodies through various provisions like security of tenure, fixed service conditions, expenses being charged on the Consolidated Fund of India, and so on.
15.
Emergency provisions. The Indian Constitution contains elaborate emergency provisions to enable the President to meet any extraordinary situation effectively. The rationality behind the incorporation of these provisions is to safeguard the sovereignty, unity, integrity and security of the country, the democratic political system and the Constitution. The Constitution envisages three types of emergencies, namely, a. National emergency on the ground of war or external aggression or armed rebellion 16, Article 352, b. State emergency, President's rule, on the ground of failure of constitutional machinery in the states, Article 356, or failure to comply with the directions of the centre, Article 365, and c. Financial emergency on the ground of threat to the financial stability or credit of India, Article 360. During an emergency, the central government becomes all-powerful and the states go into the total control of the centre. It converts the federal structure into a unitary one without a formal amendment of the constitution. This kind of transformation of the political system from federal, during normal times, to unitary, during emergency, is a unique feature of the Indian constitution. 16. Three-tier government. Originally, the Indian constitution, like any other federal constitution, provided for a dual polity and contained provisions with regard to the organization and powers of the centre and the states. Later, the 73rd and 74th Constitutional Amendment Acts, 1992, have added a third tier of government, i.e., local, which is not found in any other constitution of the world. The 73rd Amendment Act of 1992 gave constitutional recognition to the panchayats, rural local governments, by adding a new Part 917 and a new Schedule 11 to the Constitution. Similarly, the 74th Amendment Act of 1992 gave constitutional recognition to the municipalities, urban local governments, by adding a new Part 9A18 and a new Schedule 12 to the Constitution.
Table 3.1
The Constitution of India at a glance. Parts. Subject matter. Articles covered by the Union and its territory. 1 to 4. 2. Citizenship. 5 to 11. 3. Fundamental rights. 12 to 35. 4. Directive Principles of State Policy. 36 to 51. 4a. Fundamental duties. 5.1-a. We the Union Government. 52 to 151. Chapter I. The Executive. 52 to 78. Chapter 2. Parliament. 79 to 122. Chapter 3. Legislative powers of President. 123. Chapter 4. The Union Judiciary. 124 to 147. Chapter We Controller and Auditor General of India. 148 to 151. 6. The State Governments. 152 to 237. Chapter I. General. 152. Chapter 2. The Executive. 153 to 167. Chapter 3. The State Legislature. 168 to 212. Chapter 4. Legislative powers of Governor. 213. Chapter We the High Courts. 214 to 232. Chapter 6. Subordinate Courts. 233 to 237. 238.
7. The states
in Part B of the first schedule, deleted. 8. The Union Territories. 239 to 242. 9. The Panchayats. 243 to 24309. The Municipalities. 243-B to 243ZG. 9b. The Cooperative Societies. 243ZH to 243ZTX. The Scheduled and Tribal Areas. 244 to 244A. 11. Relations between the Union and the States. 245 to 263. Chapter I. Legislative Relations. 245 to 255. Chapter 2. Administrative Relations. 256 to 263. 12. Finance, Property, Contracts and Suits. 264 to 300. Chapter I. Finance. 264 to 291. Chapter 2. Borrowing. 292 to 293. Chapter 3. Property, Contracts, Rights, Liabilities, Obligations and Suits. 294 to 300. Chapter 4. Right to Property. 300-13. Trade, Commerce and Intercourse within the territory of India. 301 to 307. 14. Services under the Union and the States. 308 to 323. Chapter I. Services. 308 to 314. Chapter 2. Public Service Commissions. 315 to 323. 323-A2.
14. Tribunals.
323-3.
15. Elections.
324 to 329. 16. Special provisions relating to certain classes. 330 to 342. 17. Official language. 343 to 351. Chapter I. Language of the Union. 343 to 344. Chapter 2. Regional languages. 345 to 347. Chapter 3. Language of the Supreme Court, High Courts, and so on. 348 to 349 Chapter 4, Special Directives. 350 to 351 18 Emergency Provisions. 352 to 360 19 Miscellaneous. 361 to 367 XX Amendment of the Constitution. 368 21 Temporary, Transitional and Special Provisions. 369 to 392 22 Short Title, Commencement, Authoritative Text in Hindi and Repeals. 393 to 395 Note, Part 7, dealing with Part B states, was deleted by the 7th Amendment Act, 1956. On the other hand, both Part 4A and Part 14A were added by the 42nd Amendment Act, 1976, while Part 9A was added by the 74th Amendment Act, 1992, and Part 9B was added by the 97th Amendment Act, 2011. Table 3.2 Important Articles of the Constitution at a glance. Articles deals with 1 Name and territory of the Union. 3 Formation of new states and alteration of areas, boundaries or names of existing states.
13
Laws inconsistent with or in derogation of the fundamental rights. 14 Equality before law. 16 Equality of opportunity in matters of public employment. 17 Abolition of untouchability. 19 Protection of certain rights regarding freedom of speech, etc. 21 Protection of life and personal liberty. 21 A right to elementary education. 25 Freedom of conscience and free profession, practice and propagation of religion. 30 Right of minorities to establish and administer educational institutions.
31
Saving of laws giving effect to certain directive principles. 32 Remedies for enforcement of fundamental rights including writs. 38 State to secure a social order for the promotion of welfare of the people. 40 Organization of village panchayats. 44 Uniform Civil Code for the citizens. 45 Provision for early childhood care and education to children below the age of 6 years. 46 Promotion of educational and economic interests of scheduled castes, scheduled tribes and other weaker sections. 50 Separation of judiciary from executive. 51 Promotion of international peace and security. 51 A fundamental duties. 72 Power of President to grant pardons, etc., and to suspend, remit or commute sentences in certain cases.
74 Council of
Ministers to aid and advise the President. 78 Duties of Prime Minister as respects the furnishing of information to the President, etc. 110 Definition of money bills. 112 Annual financial statement, budget. 123 Power of President to promulgate ordinances during recess of Parliament. 143 Power of President to consult Supreme Court. 155 Appointment of Governor. 161 Power of Governor to grant pardons, etc., and to suspend, remit or commute sentences in certain cases. 163 Council of Ministers to aid and advise the Governor. 167 Duties of Chief Minister with regard to the furnishing of information to Governor, etc. 169 Abolition or creation of legislative councils in states. 200 Assent to bills by Governor, including reservation for President. 213 Power of Governor to promulgate ordinances during recess of the state legislature. 226 Power of High Courts to issue certain writs. 239 are special provisions with respect to Delhi. 249 Power of Parliament to legislate with respect to a matter in the state list in the national interest. 262 Adjudication of disputes relating to waters of interstate rivers or river valleys. 263 Provisions with respect to an interstate council. 265 Taxes not to be imposed save by authority of law. 275 Grants from the Union to certain states. 280 Finance Commission. 300 Suits and proceedings. 300 Persons not to be deprived of property save by authority of law, right to property. 311 Dismissal, removal or reduction in rank of persons employed in civil capacities under the Union or a state. 312 All India Services. 315 Public Service Commissions for the Union and for the states. 320 Functions of Public Service Commissions. 323 Administrative Tribunals. 324 Superintendents, direction and control of elections to be vested in an election commission. 330 Reservation of seats for scheduled castes and scheduled tribes in the House of the People. 335 Claims of scheduled castes and scheduled tribes to services and posts. 352 Proclamation of emergency, national emergency. 356 Provisions in case of failure of constitutional machinery in states, President's rule. 360 Provisions as to financial emergency. 365 Effect of failure to comply with, or to give effect to, directions given by the Union, President's rule. 368 Power of Parliament to amend the Constitution and procedure therefor. 370 Temporary provisions with respect to the state of Jammu and Kashmir. Table 3.3 Schedules of the Constitution at a glance. Numbers. Subject matter. Articles covered. First Schedule 1. Names of the states and their territorial jurisdiction. 1 and 4. 2. Names of the Union territories and their extent. Second Schedule. Provisions relating to the emoluments, allowances, privileges and so on of 59, 65, 75, 97, 125, 148, 158, 164, 186 and 221. 1. The President of India. 2. The Governors of States. 3. The Speaker and the Deputy Speaker of the Lok Sabha. 4. The Chairman and the Deputy Chairman of the Rajya Sabha. 5. The Speaker and the Deputy Speaker of the Legislative Assembly in the States. 6. The Chairman and the Deputy Chairman of the Legislative Council in the States. 7. The Judges of the Supreme Court. 8. The Judges of the High Courts.
9.
The Controller and Auditor General of India. Third Schedule. Forms of oaths or affirmations. 4, 75, 84, 99, 124, 146, 173, 188 and 219. 1. The Union Ministers. 2. The candidates for election to the Parliament. 3. The Members of Parliament. 4. The Judges of the Supreme Court. 5. The Controller and Auditor General of India. 6. The State Ministers. 7. The candidates for election to the State Legislature. 8. The Members of the State Legislature. 9. The Judges of the High Courts. Fourth Schedule. Allocation of seats in the Rajya Sabha to the states and the Union territories. 4 and 85th Schedule. Provisions relating to the administration and control of scheduled areas and scheduled tribes. 244 Sixth Schedule. Provisions relating to the administration of tribal areas in the states of Assam, Meghalaya, Tripura and Mizoram. 244 and 275 Division of powers between the Union and the states in terms of List I, Union List, List 2, State List, and 7th List 3, Concurrent List. Presently, the Union List 246 Schedule contains 100 subjects, originally 97, the State List contains 61 subjects, originally 66, and the Concurrent List contains 52 subjects, originally 47.
8th Schedule. Languages recognized by the
Constitution. Originally, it had 14 languages, but presently there are 22 languages. They are Assamese, Bengali, Bodo, Dogri, Dongri, Gujarati, Hindi, Kannada, Kashmiri, Konkani, Mathili, Methili, Malayalam, Manipuri, Marathi, Nepali, Orhia, Punjabi, Sanskrit, Santali, Sindhi, Tamil, Telugu and Urdu. Sindhi was added by the 21st Amendment Act of 1967, Konkani, Manipuri and Nepali were added by the 71st Amendment Act of 1992, and Bodo, Dongri, Methili and Santali were added by the 92nd Amendment Act of 2003. Oriya was renamed as Orhia by the 96th Amendment Act of 2011. 344 and 351 9th Schedule Acts and Regulations, originally 13 but presently 282, 19 of the state legislatures dealing with land reforms and abolition of the zamindari system and of the parliament dealing with other matters. This schedule was added by the First Amendment, 1951, to protect the laws included in it from judicial scrutiny on the ground of violation of fundamental rights. However, in 2007, the Supreme Court ruled that the laws included in this schedule after 24 April 1973 are now open to judicial review. 31-B 10th Schedule provisions relating to disqualification of the members of Parliament and state legislatures on the ground of defection. This schedule was added by the 52nd Amendment Act of 1985, also known as Anti-Defection Law. 102 and 191 11th Schedule specifies the powers, authority and responsibilities of panchayats. It has 29 matters. This schedule was added by the 73rd Amendment Act of 1992. 243-G specifies the powers, authority and responsibilities of
12th Schedule Municipalities.
It has 18 matters. This schedule was added by the 74th Amendment Act of 1992. 243-W Table 3.4 Sources of the Constitution at a glance. Sources features borrowed 1. Government of India Act of 1935 Federal Scheme, Office of Governor, Judiciary, Public Service Commissions, Emergency Provisions and Administrative Details. 2. British Constitution Parliamentary Government, Rule of Law, Legislative Procedure, Single Citizenship, Cabinet System, Prerogative Writs, Parliamentary Privileges and Bicameralism. 3. U.S. Constitution Fundamental Rights, Independence of Judiciary, Judicial Review, Impeachment of the President, Removal of Supreme Court and High Court Judges and Post of Vice President. 4. Irish Constitution Directive Principles of State Policy, Nomination of Members to Rajya Sabha and Method of Election of President. 5. Canadian Constitution Federation with a Stroin Centre, Vesting of Residuary Powers in the Centre, Appointment of State Governors by the Centre, and Advisory Jurisdiction of the Supreme Court. 6. Australian Constitution Concurrent List, Freedom of Trade, Commerce and Intercourse, and Joint Sitting of the two Houses of Parliament. 7. Weimar Constitution of Germany Suspension of Fundamental Rights during Emergency. Soviet Constitution Fundamental Duties and the Ideal of Justice, Social.
8.
USSR, now Russia, Economic and Political, in the Preamble. 9. French Constitution Republic and the Ideals of Liberty, Equality and Fraternity in the Preamble. 10. South African Constitution Procedure for Amendment of the Constitution and Election of Members of Rajya Sabha. 11. Japanese Procedure established by law. Constitution 17.
Cooperative
Societies. The 97th Constitutional Amendment Act of 2011 gave a constitutional status and protection to cooperative societies. In this context, it made the following 3 changes in the Constitution. 1. It made the right to form cooperative societies a fundamental right, Article 19. 2. It included a new directive principle of state policy on promotion of cooperative societies, Article 43-B. 3. It added a new Part 9b in the Constitution which is entitled as the Cooperative Societies, Articles 243ZH to 243ZT. The new Part 9b contains various provisions to ensure that the cooperative societies in the country function in a democratic, professional, autonomous and economically sound manner. It empowers the Parliament in respect of multi-state cooperative societies and the state legislatures in respect of other cooperative societies to make the appropriate law. Criticism of the Constitution. The Constitution of India as framed and adopted by the Constituent Assembly of India has been criticized on the following grounds. 1. A borrowed constitution.
The critics opine
that the Indian Constitution contains nothing new and original. They described it as a borrowed constitution, or a bag of borrowings, or a hodgepodge constitution, or a patchwork of several documents of the world constitutions. However, this criticism is unfair and illogical. This is because The framers of the constitution made necessary modifications in the features borrowed from other constitutions for their suitability to the Indian conditions, at the same time avoiding their faults. While answering the above criticism in the Constituent Assembly, Dr. B.R. Ambedkar, the chairman of the drafting committee, said, "One likes to ask whether there can be anything new in a constitution framed at this hour in the history of the world. More than 100 years have rolled over when the first written constitution was drafted. It has been followed by many countries reducing their constitutions to writing. What the scope of a constitution should be has long been settled. Similarly, what are the fundamentals of a constitution are recognized all over the world. Given these facts, all constitutions in their main provisions must look similar. The only new things, if there can be any, in a constitution framed so late in the day are the variations made to remove the faults and to accommodate it to the needs of the country. The charge of producing a blind copy of the constitutions of other countries is based, I am sure, on an inadequate study of the Constitution. 22. A carbon copy of the 1935 Act. The critics said that the framers of the Constitution have included a large number of the provisions of the Government of India Act of 1935 into the Constitution of India. Hence, they called the Constitution as a carbon copy of the 1935 Act, or an amended version of the 1935 Act. For example, N. Srinivasan observed that the Indian Constitution is, both in language and substance, a close copy of the Act of 1935. Similarly, Sir Ivor Jennings, a British constitutionalist, said that the Constitution derives directly from the Government of India Act of 1935, from which, in fact, many of its provisions are copied almost textually. Further, P.R. Deshmukh, a member of the Constituent Assembly, commented that the Constitution is essentially the Government of India Act
of
1935 with only adult franchise added. The same Dr. B.R. Ambedkar answered the above criticism in the Constituent Assembly in the following way: as to the accusation that the draft constitution has reproduced a good part of the provisions of the Government of India Act 1935, I make no apologies. There is nothing to be ashamed of in borrowing. It involves no plagiarism. Nobody holds any patent rights in the fundamental ideas of a constitution. What I am sorry about is that the provisions taken from the Government of India Act 1935 relate mostly to the details of administration. 21.3. Un-Indian or anti-Indian. According to the critics, the Indian constitution is un-Indian or anti-Indian because it does not reflect the political traditions and the spirit of India. They said that the foreign nature of the constitution makes it unsuitable to the Indian situation or unworkable in India. In this context, K. Hanumanthaya, a member of the Constituent Assembly, commented, "We wanted the music of veena or sitar, but here we have the music of an English band. That was because our constitution makers were educated that way." 22. Similarly, Loknath Misra, another member of the Constituent Assembly, criticized the constitution as a slavish imitation of the West, much more a slavish surrender to the West. 23. Further, Lakshmi Narayan Sahu, also a member of the Constituent Assembly, observed, "The ideals on which this draft constitution is framed have no manifest relation to the fundamental spirit of India. This constitution would not prove suitable and would break down soon after being brought into operation." 24.4. An Ungandhian constitution. According to the critics, the Indian constitution is Ungandhian because it does not contain the philosophy and ideals of Mahatma Gandhi, the father of the Indian nation. They opined that the constitution should have been raised and built upon village panchayats and district panchayats. In this context, the same member of the Constituent Assembly, K. Hanumanthaya, said, "That is exactly the kind of constitution Mahatma Gandhi did not want and did not envisage." 25. T. Prakasam, another member of the Constituent Assembly,
attributed
this lapse to
Ambedkar's
Ambedkar's non-participation in the Gandhian movement and the antagonism towards Gandhian ideas. 26.5. Elephantine size. The critics stated that the Indian constitution is too bulky and too detailed and contains some unnecessary elements. Sir Ivor Jennings, a British constitutionalist, observed that the provisions borrowed were not always well selected and that the constitution, generally speaking, was too long and complicated. 27 In this context, H.V. Kamath, a member of the Constituent Assembly, commented, "The emblem and the crest that we have selected for our assembly is an elephant. It is perhaps in consonance with that our constitution too is the bulkiest that the world has produced." 28 He also said, "I am sure the House does not agree that we should make the constitution an elephantine one." 29 Paradise of the lawyers. According to the critics, the Indian constitution is too legalistic and very complicated. They opined that the legal language and phraseology adopted in the constitution makes it a complex document. The same Sir Ivor Jennings called it a lawyer's paradise. In this context, H.K. Maheshwaram, a member of the Constituent Assembly, observed, "The draft tends to make people more litigious, more inclined to go to law courts, less truthful and less likely to follow the methods of truth and non-violence. If I may say so, the draft is really a lawyer's paradise. It opens up vast avenues of litigation and will give our able and ingenious lawyers plenty of work to do." 30 Similarly, P.R. Deshmukh, another member of the Constituent Assembly, said, "I should, however, like to say that the draft of the articles that have been brought before the House by Dr. Ambedkar seems to my mind to be far too ponderous, like the ponderous tomes of a law manual. A document dealing with the Constitution hardly uses so much of padding and so much of verbiage. Perhaps it is difficult for them to compose a document which should be, to my mind, not a law manual but a socio-political document, a vibrating, pulsating and life-giving document. But to our misfortune, that was not to be, and we have been burdened with so much of words which could have been very easily eliminated." 31 Notes and References. 1. Keswananda Bharti V. State of Kerala, 1973. 2. For details on parts, important articles and schedules, see tables 3.1, 3.2 and 3.3 at the end of this chapter. 3. The American Constitution originally consisted of only 7 articles, the Australian 128, the Chinese 138, and the Canadian 147. 4. The state of Jammu and Kashmir has its own constitution and thus enjoys a special status by virtue of Article 370 of the Constitution of India. 5. About 250 provisions of the 1935 Act have been included in the Constitution. 6. Constituent Assembly Debates, Volume 7, p. 35-38. 7. P. M. Bakshi, The Constitution of India, Universal, 5th edition, 2002, p. 4. 8. See Table 3.4 at the end of this chapter. 9. Brij Kishore Sharma, Introduction to the Constitution of India, 7th edition, 2015, P. Learning Private Limited, p. 42. 10. Westminster is a place in London where the British Parliament is located. It is often used as a symbol synonym of the British Parliament. 11. Originally, the Constitution provided for 7 fundamental rights. However, the right to own property, Article 31, was deleted from its list of fundamental rights by the 44th Amendment Act of 1978. It is made a legal right under Article 300 in Part 12 of the Constitution. 12. Minerva Mills v. Union of India, 1980. 13. The 1909, 1919, and 1935 Acts provided for communal representation. 14. Even in the Western countries, the right to vote was extended only gradually. For example, USA gave franchise to women in 1920, Britain in 1928, USSR, now Russia, in 1936, France in 1945, Italy in 1948 and Switzerland in 1971. 15. At present, there are 3 All India services, namely Indian
Administrative
Service,
IS,
Indian Police Service, IPS, and Indian Forest Service, IFS. In 1947, Indian Civil Service, ICS, was replaced by IAS, and the Indian Police, IP, was replaced by IPS and were recognized by the Constitution as All India Services. In 1963,
IFS was created
and it came into existence in 1966. 16. The 44th Amendment Act, 1978, has replaced the original term, internal disturbance, by the new term, armed rebellion. 17. Part 9 of the Constitution provides for a three-tier system of Panchayati Raj in every state, that is, Panchayats at the village, intermediate and district levels. 18. Part 9A of the Constitution provides for three types of municipalities in every state, that is, Nagar Panchayat for a transitional area, Municipal Council for a smaller urban area, and Municipal Corporation for a larger urban area. 19. Though the last entry is numbered 284, the actual total number is 282. This is because 3 entries, 87, 92 and 130, have been deleted, and 1 entry is numbered as 257-A20. Constituent Assembly Debates, Volume 7, pp.35-38. 21. IBID. 22. Constituent Assembly Debates, Volume 11, p.616. 23. Constituent Assembly Debates, Volume 7, p.242. 24. Constituent Assembly Debates, Volume 11, p.613. 25. Constituent Assembly Debates, Volume 11, p.617. 26. Constituent Assembly Debates, Volume 7, p.387. 27. Ivor Jennings, Some Characteristics of the Indian Constitution, Oxford University Press, Madras, 1953, pp.9-16. 28. Constituent Assembly Debates, Volume 7, p.1042. 29. Constituent Assembly Debates, Volume 8, p.127. 30. Constituent Assembly Debates, Volume 7, p.293. 31. Constituent Assembly Debates, Volume 9, p.613. Preamble of the Constitution. The American Constitution was the first to begin with the preamble. Many countries, including India, followed this practice. The term preamble refers to the introduction or preface to the Constitution. It contains the summary or essence of the Constitution. N.A. Palkiwala, an eminent jurist and constitutional expert, called the preamble as the identity card of the Constitution. The preamble to the Indian Constitution is based on the Objectives Resolution, drafted and moved by Pandit Nehru, and adopted by the Constituent Assembly 1. It has been amended by the 42nd Constitutional Amendment Act, 1976, which added 3 new words: socialist, secular and integrity. Text of the preamble. The preamble in its present form reads, "We, the people of India, having solemnly resolved to constitute India into a sovereign socialist secular democratic republic and to secure to all its citizens, justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all fraternity assuring the dignity of the individual and the unity and integrity of the nation, in our Constituent Assembly this 26th day of November, 1949, do hereby adopt, enact and give to ourselves this Constitution." Ingredients of the preamble. The preamble reveals 4 ingredients or components. 1. Source of authority of the Constitution. The preamble states that the Constitution derives its authority from the people of India. 2. Nature of Indian state. It declares India to be of a sovereign, socialist, secular democratic and republican polity. 3. Objectives of the Constitution. It specifies justice, liberty, equality and fraternity as the objectives. 4. Date of adoption of the Constitution. It stipulates 26 November 1949 as the date. Keywords in the preamble: certain keywords: sovereign, socialist, secular, democratic, republic, justice, liberty, equality and fraternity, are explained as follows. 1. Sovereign. The word sovereign implies that India is neither a dependency nor a dominion of any other nation, but an independent state. 2. There is no authority above it, and it is free to conduct its own affairs, both internal and external. Though in 1949, India declared the continuation of her full membership of the Commonwealth of Nations and accepted the British Crown as the head of the Commonwealth, this extra-constitutional declaration does not affect India's sovereignty in any manner. 3. Further, India's membership of the United Nations Organization, UNO, also in no way constitutes a limitation on her sovereignty. 4.
Being a sovereign
state, India can either acquire a foreign territory or cede a part of its territory in favor of a foreign state. 2. Socialist. Even before the term was added by the 42nd Amendment in 1976, the Constitution had a socialist content in the form of certain directive principles of state policy. In other words, what was hitherto implicit in the Constitution has now been made explicit. Moreover, the Congress Party itself adopted a Resolution 5 to establish a socialistic pattern of society in its Avadi session as early as in 1955 and took measures accordingly. Notably, the Indian brand of socialism is a democratic socialism, and not a communistic socialism, also known as state socialism, which involves the nationalization of all means of production and distribution and the abolition of private property. Democratic socialism, on the other hand, holds faith in a mixed economy, where both public and private sectors coexist side by side. 6. As the Supreme Court says, democratic socialism aims to end poverty, ignorance, disease and inequality of opportunity. 7. Indian socialism is a blend of Marxism and Gandhism, leaning heavily towards Gandhian socialism. 8. The new economic policy, 1991, of liberalization, privatization and globalization has, however, diluted the socialist credentials of the Indian state. 3. Secular. The term secular, too, was added by the 42nd Constitutional Amendment Act of 1976. However, as the Supreme Court said in 1974, although the words secular and state 9 were not expressly mentioned in the Constitution, there can be no doubt that Constitution makers wanted to establish such a state, and accordingly Articles 25 to 28, guaranteeing the fundamental right to freedom of religion, have been included in the Constitution. The Indian Constitution embodies the positive concept of secularism, i.e., all religions in our country, irrespective of their strength, have the same status and support from the state. 10.
For
democratic 11. Polity, as stipulated in the preamble, is based on the doctrine of popular sovereignty, that is, possession of supreme power by the people. Democracy is of two types, direct and indirect. In direct democracy, the people exercise their supreme power directly, as is the case in Switzerland. There are 4 devices of direct democracy, namely, referendum, initiative, recall and plebiscite. 12. In indirect democracy, on the other hand, the representatives elected by the people exercise the supreme power and thus carry on the government and make the laws. This type of democracy, also known as representative democracy, is of 2 kinds, parliamentary and presidential. The Indian Constitution provides for representative parliamentary democracy, under which the executive is responsible to the legislature for all its policies and actions. Universal adult franchise, periodic elections, rule of law, independence of judiciary, and absence of discrimination on certain grounds are the manifestations of the democratic character of the Indian polity. The term democratic is used in the preamble in the broader sense, embracing not only political democracy but also social and economic democracy. This dimension was stressed by Dr. Ambedkar in his concluding speech in the Constituent Assembly on 25 November 1949, in the following way: political democracy cannot last unless there lies at the base of it social democracy. What does social democracy mean? It means a way of life which recognizes liberty, equality and fraternity. The principles of liberty, equality and fraternity are not to be treated as separate items in a trinity. They form a union of trinity in the sense that to divorce one from the other is to defeat the very purpose of democracy. Liberty cannot be divorced from equality, equality cannot be divorced from liberty. Nor can liberty and equality be divorced from fraternity. Without equality, liberty would produce the supremacy of the few over the many. Equality without liberty would kill individual initiative. 12 In the same context, the Supreme Court observed in 1997 that the Constitution envisions to establish an egalitarian social order rendering to every citizen social, economic and political justice in a social and economic democracy of the Bharat Republic. 5. Republic. A democratic polity can be classified into two categories, monarchy and republic. In a monarchy, the head of the state, usually king or queen, enjoys a hereditary position, that is, he comes into office through succession, egg, Britain. In a republic, on the other hand, the head of the state is always elected directly or indirectly for a fixed period, egg, USA. Therefore, the term, republic, in our preamble indicates that India has an elected head called the President. He is elected indirectly for a fixed period of 5 years. A republic also means two more things. 1. Vesting of political sovereignty in the people and not in a single individual like a king. 2. The absence of any privileged class and hence all public offices being open to every citizen without any discrimination. 6. Justice. The term, justice, in the preamble embraces three distinct forms, social, economic and political, secured through various provisions of fundamental rights and directive principles. Social justice denotes the equal treatment of all citizens without any social distinction based on caste, color, race, religion, sex and so on. It means absence of privileges being extended to any particular section of the society, and improvement in the conditions of backward classes, SCs, STs and OBCs, and women. Economic justice denotes the non-discrimination between people on the basis of economic factors. It involves the elimination of glaring inequalities in wealth, income and property. A combination of social justice and economic justice denotes what is known as distributive justice. Political justice implies that all citizens should have equal political rights, equal access to all political offices and equal voice in the government.
The idea
of justice, social, economic and political, has been taken from the Russian Revolution, 1917. 7. Liberty. The term, liberty, means the absence of restraints on the activities of individuals, and at the same time, providing opportunities for the development of individual personalities. The preamble secures to all citizens of India liberty of thought, expression, belief, faith and worship, through their fundamental rights, enforceable in court of law, in case of violation. Liberty as elaborated in the preamble is very essential for the successful functioning of the Indian democratic system. However, liberty does not mean license to do what one likes, and has to be enjoyed within the limitations mentioned in the Constitution itself. In brief, the liberty conceived by the preamble or fundamental rights is not absolute but qualified. The ideals of liberty, equality and fraternity in our preamble have been taken from the French Revolution, 1789-1799. 8. Equality. The term, equality, means the absence of special privileges to any section of the society, and the provision of adequate opportunities for all individuals without any discrimination. The preamble secures to all citizens of India equality of status and opportunity. This provision embraces three dimensions of equality: civic, political and economic. The following provisions of the chapter on fundamental rights ensure civic equality. A. Equality before the law, Article 14. B. Prohibition of discrimination on grounds of religion, race, caste, sex or place of birth, Article 15. C. Equality of opportunity in matters of public employment, Article 16. D. Abolition of untouchability, Article 17. E. Abolition of titles, Article 18.
There are two
There are two
provisions
provisions in the Constitution that seek to achieve political equality. 1. No person is to be declared ineligible for inclusion in electoral rolls on grounds of religion, race, caste or sex, Article 325. 2. Elections to the Lok Sabha and the state assemblies to be on the basis of adult suffrage, Article 326. The Directive Principles of State Policy, Article 39, secures to men and women equal right to an adequate means of livelihood and equal pay for equal work. 9. Fraternity. Fraternity means a sense of brotherhood. The Constitution promotes this feeling of fraternity by the system of single citizenship. Also, the fundamental duties, Article 51-A, say that it shall be the duty of every citizen of India to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, regional or sectional diversities. The Preamble declares that fraternity has to assure two things: the dignity of the individual and the unity and integrity of the nation. The word integrity has been added to the Preamble by the 42nd Constitutional Amendment, 1976. According to K.M. Munshi, a member of the drafting committee of the Constituent Assembly, the phrase, dignity of the individual, signifies that the Constitution not only ensures material betterment and maintain a democratic setup, but that it also recognizes that the personality of every individual is sacred. This is highlighted through some of the provisions of the fundamental rights and directive principles of state policy, which ensure the dignity of individuals. Further, the fundamental duties, Article 51A, also protect the dignity of women by stating that it shall be the duty of every citizen of India to renounce practices derogatory to the dignity of women, and also makes it the duty of every citizen of India to uphold and protect the sovereignty, unity and integrity of India. The phrase, unity and integrity of the nation, embraces both the psychological and territorial dimensions of national integration. Article 1 of the Constitution describes India as a union of states to make it clear that
the states have no right
to secede from the Union, implying the indestructible nature of the Indian Union.
It aims
It
at
aims at
overcoming
overcoming hindrances to national integration like communalism, regionalism, casteism, linguism, secessionism and so on. Significance of the Preamble. The Preamble embodies the basic philosophy and fundamental values, political, moral and religious, on which the Constitution is based. It contains the grand and noble vision of the Constituent Assembly, and reflects the dreams and aspirations of the founding fathers of the Constitution. In the words of Sir Alladi Krishnaswamy Iyer, a member of the Constituent Assembly who played a significant role in making the Constitution, the Preamble to our Constitution expresses what we had thought or dreamt so long. According to K.M. Munshi, a member of the drafting committee of the Constituent Assembly, the Preamble is the horoscope of our sovereign democratic republic. Pandit Thakor Das Bhargava, another member of the Constituent Assembly, summed up the importance of the Preamble in the following words: the Preamble is the most precious part of the Constitution. It is the soul of the Constitution. It is a key to the Constitution. It is a jewel set in the Constitution. It is a proper yardstick with which one can measure the worth of the Constitution. Sir Ernest Barker, a distinguished English political scientist, paid a glowing tribute to the political wisdom of the authors of the Preamble. He described the Preamble as the keynote 13 to the Constitution. He was so moved by the text of the Preamble that he quoted 14 it at the opening of his popular book, Principles of Social and Political Theory, 1951. M. Hidayatullah, a former Chief Justice of India, observed, "Preamble resembles the Declaration of Independence of the United States of America, but is more than a declaration. It is the soul of our Constitution, which lays down the pattern of our political society. It contains a solemn resolve, which nothing but a revolution can alter." 15.
Preamble
as part of the Constitution. One of the controversies about the preamble is as to whether it is a part of the Constitution or not. In the Berubari Union 16 case, 1960, the Supreme Court said that the preamble shows the general purposes behind the several provisions in the Constitution, and is thus the key to the minds of the makers of the Constitution. Further, where the terms used in any article are ambiguous or capable of more than one meaning, some assistance at interpretation may be taken from the objectives enshrined in the preamble. Despite this recognition of the significance of the preamble, the Supreme Court specifically opined that preamble is not a part of the Constitution. In the Keswananda Varki case 17, 1973, the Supreme Court rejected the earlier opinion and held that preamble is a part of the Constitution. It observed that the preamble is of extreme importance and the Constitution should be read and interpreted in the light of the grand and noble vision expressed in the preamble. In the LIC of India case 18, 1995, also, the Supreme Court again held that the preamble is an integral part of the Constitution. Like any other part of the Constitution, the preamble was also enacted by the Constituent Assembly, but, after the rest of the Constitution was already enacted. The reason for inserting the preamble at the end was to ensure that it was in conformity with the Constitution as adopted by the Constituent Assembly. While forwarding the preamble for votes, the President of the Constituent Assembly said, "The question is that preamble stands part of the Constitution 19. The motion was then adopted. Hence, the current opinion held by the Supreme Court that the preamble is a part of the Constitution, is in consonance with the opinion of the founding fathers of the Constitution. However, two things should be noted. One, the preamble is neither a source of power to legislature nor a prohibition upon the powers of legislature. Two, it is non-justiciable, that is, its provisions are not enforceable in courts of law. Amendability of the preamble. The question as to whether the preamble can be amended under Article 368 of the Constitution arose for the first time in the historic case of Keswananda Varki, 1973. It was urged that the preamble cannot be amended as it is not a part of the Constitution. The petitioner contended that the amending power in Article 368 cannot be used to destroy or damage the basic elements or the fundamental features of the Constitution, which are enshrined in the preamble. The Supreme Court, however, held that the preamble is a part of the Constitution. The court stated that the opinion tendered by it in the Berubari Union, 1960, in this regard was wrong, and held that the preamble can be amended, subject to the condition that no amendment is done to the basic features. In other words, the court held that the basic elements or the fundamental features of the Constitution as contained in the preamble cannot be altered by an amendment under Article 36,820. The preamble has been amended only once so far, in 1976, by the 42nd Constitutional Amendment Act, which has added 3 new words, socialist, secular and integrity, to the preamble. This amendment was held to be valid. Notes and references. 1. Moved by Nehru on 13 December 1946 and adopted by the Constituent Assembly on 22 January 1947. 2. Till the passage of the Indian Independence Act, 1947, India was a dependency, colony, of the British Empire. From 15 August 1947 to 26 January 1950, India's political status was that of a dominion in the British Commonwealth of Nations. India ceased to be a British dominion on 26 January 1950, by declaring herself a sovereign republic. However, Pakistan continued to be a British dominion until 1956. 3. To dispel the lurking fears of some members of the Constituent Assembly, Pandit Nehru said in 1949 thus, "We took pledge long ago to achieve Purna Swaraj. We have achieved it. Does a nation lose its independence by an alliance with another country? Alliance normally means commitments. The free association of the sovereign. Commonwealth of Nations does not involve such commitments. Its very strength lies in its flexibility and its complete freedom. It is well known that it is open to any member nation to go out of the Commonwealth if it so chooses. He further stated, it is an agreement by free will, to be terminated by free will. 4. India became a member of the UN in 1945. 5. The resolution said, in order to realize the object of Congress and to further the objectives stated in the Preamble and Directive Principles of State Policy of the Constitution of India, planning should take place with a view to the establishment of a socialistic pattern of society, where the principal means of production are under social ownership or control, production is progressively speeded up and there is equitable distribution of the national wealth. 6. The Prime Minister, Indira Gandhi, said, we have always said that we have our own brand of socialism. We will nationalize the sectors where we feel the necessity. Just nationalization is not our type of socialism. 7. G.B. Pant University of Agriculture and Technology V State of Uttar Pradesh, 2000. 8. Nakara V Union of India, 1983. 9. On the basis of the attitude of the state towards religion, 3 types of states can be conceived of. A. Atheistic state, the state is anti-religion and hence, condemns all religions. B. Theocratic state, the state is pro-religion and hence, declares one particular religion as the state religion, as for example, Bangladesh, Burma, Sri Lanka, Pakistan, and so on. C. Secular state, the state is neutral in the matter of religion and hence, does not uphold any particular religion as the state religion, as for example, USA and India. G.S. Pandey, Constitutional Law of India, Allahabad Law Agency, 8th edition, 2002, p. 222. 10. The then Union Law Minister, H.R. Gokhale defined this concept as, there will be freedom, liberty of faith and worship, whatever religion you belong to. The state will not have anything to do, as a state, with any religion excepting to treat every religion equally, but the state will not have any foundation of religion. Similarly, P.B. Gajendragdaka, a former Chief Justice of India, defined secularism as in the Indian Constitution in
the following way. The state
does not owe loyalty to any particular religion as such. It is not irreligious or anti-religious, it gives equal freedom to all religions. 11. The term, democracy, is derived from 2 Greek words, namely, demos and kratia meaning, people, and rule, respectively. 12. Referendum is a procedure whereby a proposed legislation is referred to the electorate for settlement by their direct votes. Initiative is a method by means of which the people can propose a bill to the legislature for enactment. Recall is a method by means of which the voters can remove a representative or an officer before the expiry of his term, when he fails to discharge his duties properly. Plebiscite is a method of obtaining the opinion India's of people on any issue of public importance. It is generally used to solve the territorial disputes. 12. A.B. Shiva Rao, The Framing of India's Constitution, Select Documents, Volume 4, p. 944. 13. He said that the preamble of the Indian Constitution states, in a brief and pithy form the argument of much of the book, and it may accordingly serve as a keynote. 14. He wrote, I am all the more moved to quote it because I am proud that the people of India should begin their independent life by subscribing to the principles of a political tradition which we in the West call Western, but which is now something more than the Western. 15. M. Hidayatullah, Democracy in India and the Judicial Process, p. 51. 16. Reference by the President of India under Article 143 of the Constitution on the implementation of the Indo-Pakistan Agreement relating to Berubari Union and Exchange of Enclaves, 1960. 17. Keswananda Bharti v State of Kerala, 1973. 18. LIC of India v Consumer Education and Research Centre, 1995. 19. Constituent Assembly Debates, Volume 10, p. 454-56. 20. The Court observed, the edifice of our Constitution is based upon the basic elements mentioned in the Preamble. If any of these elements are removed, the structure will not survive and it will not be the same Constitution or it cannot maintain its identity. An amending power cannot be interpreted so as to confer power on the Parliament to take away any of
these
fundamental and basic characteristics of the polity. Union and its territory. Articles 1 to 4 under Part I of the Constitution deal with the Union and its territory. A union of states. Article 1 describes India, that is, Bharat, as a union of states rather than a federation of states. This provision deals with two things: 1. Name of the country, and 2. Type of polity. There was no unanimity in the Constituent Assembly with regard to the name of the country. Some members suggested the traditional name, Bharat, while others advocated the modern name, India. Hence, the Constituent Assembly had to adopt a mix of both, India, that is, Bharat. Secondly, the country is described as Union, although its constitution is federal in structure. According to Dr. B.R. Ambedkar, the phrase, Union of States has been preferred to Federation of States for two reasons. 1. The Indian Federation is not the result of an agreement among the states like the American Federation, and 2. The states have no right to secede from the Federation. The Federation is an union because it is indestructible. The country is an integral whole and divided into different states only for the convenience of administration. 1.
According
to Article 1, the territory of India can be classified into three categories: 1. Territories of the states; 2. Territories; 3. Territories that may be acquired by the government of India at any time. The names of states and union territories and their territorial extent are mentioned in the first schedule of the Constitution. At present, there are 29 states and 7 union territories. The provisions of the Constitution pertaining to the states are applicable to all the states, except Jammu and Kashmir, too in the same manner. However, the special provisions, under Part 21, applicable to the states of Maharashtra, Gujarat, Nagaland, Assam, Manipur, Andhra Pradesh, Telangana, Sikkim, Mizoram, Arunachal Pradesh, Goa and Karnataka override the general provisions relating to the states as a class. Further, the 5th and 6th schedules contain separate provisions with respect to the administration of scheduled areas and tribal areas within the states. Notably, the territory of India is a wider expression than the Union of India, because the latter includes only states while the former includes not only the states but also union territories and territories that may be acquired by the government of India at any future time. The states are the members of the federal system and share a distribution of powers with the center. The union territories and the acquired territories, on the other hand, are directly administered by the central government. Being a sovereign state, India can acquire foreign territories according to the modes recognized by international law, i.e., cession, following treaty, purchase, gift, lease or plebiscite, occupation, hitherto unoccupied by a recognized ruler, conquest or subjugation. For example, India acquired several foreign territories such as Dadra and Nagar Haveli, Goa, Daman and Diu, Puducherry, and Sikkim since the commencement of the Constitution. The acquisition of these territories are discussed later in this chapter. Article 2 empowers the Parliament to admit into the Union of India, or establish new states on such terms and conditions as it thinks fit. Thus, Article 2 grants two powers to the Parliament: a. The power to admit into the Union of India new states, and b. The power to establish new states. The first refers to the admission of states which are already in existence, while the
second refers to the establishment
of states which were not in existence before. Notably, Article 2 relates to the admission or establishment of new states that are not part of the Union of India.
Article 3,
on the other hand, relates to the formation of or changes in the existing states of the Union of India. In other words, Article 3 deals with the internal readjustment inter se of the territories of the constituent states of the Union of India. Parliament's power to reorganize the states. Article 3 authorizes the Parliament to a. form a new state by separation of territory from any state or by uniting two or more states or parts of states or by uniting any territory to a part of any state. B. Increase the area of any state. C. Diminish the area of any state. D. Alter the boundaries of any state. And E. Alter the name of any state. However, Article 3 lays down two conditions in this regard. 1. A bill contemplating the above changes can be introduced in the Parliament only with the prior recommendation of the President, and 2. Before recommending the bill, the President has to refer the same to the state legislature concerned for expressing its views within a specified period. Further, the power of Parliament to form new states includes the power to form a new state or union territory by uniting a part of any state or union territory to any other state or union territory. 3. The President, or Parliament, is not bound by the views of the state legislature and may either accept or reject them, even if the views are received in time. Further, it is not necessary to make a fresh reference to the state legislature every time an amendment to the bill is moved and accepted in Parliament. 4. In case of a union territory, no reference need be made to the concerned legislature to ascertain its views, and the Parliament can itself take any action as it deems fit. It is thus clear that the Constitution authorizes the Parliament to form new states or alter the areas, boundaries or names of the existing states without their consent. In other words, the Parliament can redraw the political map of
India according to its will. Hence, the
territorial integrity or continued existence of any state is not guaranteed by the Constitution. Therefore, India is rightly described as an indestructible union of destructible states. The union government can destroy the states, whereas the state governments cannot destroy the union. In USA, on the other hand, the territorial integrity or continued existence of a state is guaranteed by the Constitution. The American federal government cannot form new states or alter the borders of existing states without the consent of the states concerned. That is why the USA is described as an indestructible union of indestructible states. Moreover, the Constitution, Article 4, itself declares that laws made for admission or establishment of new states, under Article 2, and formation of new states and alteration of areas, boundaries or names of existing states, under Articles 3, are not to be considered as amendments of the Constitution under Article 368. This means that such laws can be passed by a simple majority and by the ordinary legislative process. Does the power of Parliament to diminish the areas of a state, under Article 3, include also the power to cede Indian territory to a foreign country? This question came up for examination before the Supreme Court in a reference made by the President in 1960. The decision of the central government to cede part of a territory known as Berubari Union, West Bengal, to Pakistan led to political agitation and controversy and thereby necessitated the presidential reference. The Supreme Court held that the power of Parliament to diminish the area of a state, under Article 3, does not cover cession of Indian territory to a foreign country. Hence, Indian territory can be ceded to a foreign state only by amending the Constitution under Article 368. Consequently, the 9th Constitutional Amendment Act, 1960, was enacted to transfer the said territory to Pakistan. On the other hand, the Supreme Court in 1969 ruled that settlement of a boundary dispute between India and another country does not require a constitutional amendment. It can be done by executive action as it does not involve cession of Indian territory to a foreign country. The 100th Constitutional Amendment Act, 2015, was enacted to give effect to the acquiring of certain territories by India and transfer of certain other territories to Bangladesh in pursuance of the agreement and its protocol entered into between the governments of India and Bangladesh. Under this
deal, India transferred 3
enclaves to Bangladesh, while Bangladesh transferred 51 enclaves to India. In addition, the deal also involved the transfer of adverse possessions and the demarcation of a 6.1 km undemarcated border stretch. For these three purposes, the amendment modified the provisions relating to the territories of 4 states, Assam, West Bengal, Meghalaya and Tripura, in the first schedule of the Constitution. The background of this amendment is as follows. 1. India and Bangladesh have a common land boundary of approximately 4,096.7 km. The India-East Pakistan land boundary was determined as per the Radcliffe Award of 1947. Disputes arose out of some provisions in the Radcliffe Award, which were sought to be resolved through the Bagay Award of 1950. Another effort was made to settle these disputes by the Nehru-Noon Agreement of 1958. However, the issue relating to division of Berubari Union was challenged before the Supreme Court. To comply with the opinion rendered by the Supreme Court, the Constitution, 9th Amendment, Act, 1960 was passed by the Parliament. Due to the continuous litigation and other political developments at that time, the Constitution, 9th Amendment, Act, 1960 could not be notified in respect of territories in former East Pakistan, presently Bangladesh. 4.2. On 16 May 1974, the agreement between India and Bangladesh concerning the demarcation of the land boundary and related matters was signed between both the countries to find a solution to the complex nature of the border demarcation involved. This agreement was not ratified as it involved, inter alia, transfer of territory which requires a constitutional amendment. In this connection, it was also required to identify the precise area on the ground which would be transferred. Subsequently, the issues relating to demarcation of undemarcated boundary, the territories in adverse possession, and exchange of enclaves were identified and resolved by signing a protocol on 6 September 2011, which forms an integral part of the land boundary agreement between India and Bangladesh, 1974. The protocol was prepared with support and concurrence of the concerned state governments of Assam, Meghalaya, Tripura and West Bengal. 4b Evolution of states and union territories. Integration of princely states. At the time of independence, India comprised two categories of political units, namely, the British provinces, under the direct rule of British government, and the princely states, under the rule of native princes but subject to the paramountcy of the British Crown. The Indian Independence Act, 1947, created two independent and separate dominions of India and Pakistan and gave three options to the princely states, viz. Joining India, joining Pakistan or remaining independent. Of the 552 princely states situated within the geographical boundaries of India, 549 joined India and the remaining three, Hyderabad, Junagadh and Kashmir, refused to join India. However, in course of time, they were also integrated with India, Hyderabad by means of police action, Junagadh by means of referendum and Kashmir by the instrument of accession. In 1950, the Constitution contained a fourfold classification of the states of the Indian Union, Part A, Part B, Part C and Part D. State 5. In all, they numbered 29. Part A states comprised 9 erstwhile governors' provinces of British India. Part B states consisted of 9 erstwhile princely states with legislatures. Part C states consisted of erstwhile chief commissioners' provinces of British India and some of the erstwhile princely states. These Part C states, in all 10 in number, were centrally administered. The Andaman and Nicobar Islands were kept as the solitary Part D state. Table 5.1 Territory of India in 1950 states in Part A, states in Part B, states in Part C, states in Part D. 1. Assam 1. Hyderabad 1. Ajmer 1. Andaman and Nicobar Islands 2. Bihar 2. Jammu and Kashmir 2. Bhopal 3. Bombay 3. Madhya Bharat 3. Bilaspur 4. Madhya 4. Mysore 4. Kuch Pradesh Bihar 5. Madras 5. Patiala and East Punjab 5. Coorg 6. Orissa 6. Rajasthan 6. Delhi 7. Punjab 7. Saurashtra 7. Himachal Pradesh 8. United Provinces 8. Travancore Cochin 8. Kutch 9. West Bengal 9. Vindhya Pradesh 9. Manipur 10. Tripura. The Commission and JVP Committee. The integration of princely states with the rest of India has purely an ad hoc arrangement. There has been a demand from different regions, particularly South India, for reorganization of states on linguistic basis. Accordingly, in June 1948, the Government of India appointed the Linguistic Provinces Commission under the chairmanship of S.K. Dha to examine the feasibility of this. The Commission submitted its report in December 1948 and recommended the reorganization of states on the basis of administrative convenience rather than linguistic factor. This created much resentment and led to the appointment of another Linguistic Provinces Committee by the Congress in December 1948 itself to examine the whole question afresh. It consisted of Jawaharlal Nehru, Vallabhbhai Patel and Pattabhi Sitaramaiah and hence was popularly known as JVP Committee 6. It submitted its report in April 1949 and formally rejected language as the basis for reorganization of states. However, in October 1953, the Government of India was forced to create the first linguistic state, known as Andhra State, by separating the Telugu-speaking areas from the Madras state. This followed a prolonged popular agitation and the death of Poti Sriramulu, a congressperson of standing, after a 56-day hunger strike for the cause. Fazla Ali commissioned the creation of Andhra state intensified the demand from other regions for creation of states on linguistic basis. This forced the Government of India to appoint, in December 1953, a three-member States Reorganization Commission under the chairmanship of Fazla Ali to re-examine the whole question. Its other two members were K.M. Panikkar and H.N. Kunzru. It submitted its report in September 1955 and broadly accepted language as the basis of reorganization of states. But, it rejected the theory of one language, one state. Its view was that the unity of India should be regarded as the primary consideration in any redrawing of the country's political units. It identified four major factors that can be taken into account in any scheme of reorganization of states. A. Preservation and strengthening of the unity and security of the country. B. Linguistic and cultural homogeneity. C. Financial, economic and administrative considerations. D. Planning and promotion of the welfare of the people in each state as well as of the nation as a whole. The Commission suggested the abolition of the fourfold classification of states under the original constitution and creation of 16 states and 3 centrally administered territories. The Government of India accepted these recommendations with certain minor modifications. By the States Reorganization Act, 1956, and the 7th Constitutional Amendment Act, 1956, the distinction between Part A and Part B states was done away with and Part C states were abolished. Some of them were merged with adjacent states and some other were designated as union territories. As a result, 14 states and 6 union territories were created on November 1, 1956.7 Table 5.2 Territory of India in 1956 States Union Territories 1. Andhra Pradesh 1. Andaman and Nicobar Islands 2. Assam 2. Delhi 3. Bihar 3. Himachal Pradesh 4. Bombay 4. Lakshadweep, Minikoy and Amindevi Islands 5. Jammu and Kashmir 5. Manipur 6. Kerala 6. Tripura 7. Madhya Pradesh 8. Madras 9. Mysore 10. Orissa 11. Punjab 12. Rajasthan 13. Uttar Pradesh 14. West Bengal. The States Reorganization Act of 1956 established a new state of Kerala by merging the Travancore Cochin state with the Malabar district of Madras state and Kasaragod of South Kendra, Dakshina Kannada. It merged the Telugu-speaking areas of Hyderabad state with the Andhra state to create the Andhra Pradesh state. Further, it merged the Madhya Bharat state, Vindhya Pradesh state and Bhopal state into the Madhya Pradesh state. Similarly, it merged the Saurashtra state and Kutch state into that of the Bombay state, the Coorg state into that of Mysore state, the Patiala and East Punjab states union, PEPSU, into that of Punjab state, and the Ajmer state into that of Rajasthan state. Moreover, it created the new union territory of Lakshadweep, Minikoi and Amindevi Islands from the territory detached from the Madras state. New states and union territories created after 1956. Even after the large-scale reorganization of the states in 1956, the political map of India underwent continuous change due to the pressure of popular agitations and political conditions. The demand for the creation of some more states on the basis of language or cultural homogeneity resulted in the bifurcation of existing states. Maharashtra and Gujarat in 1960, the bilingual state of Bombay was divided into two separate states, Maharashtra for Marathi-speaking people and Gujarat for Gujarati-speaking people. Gujarat was established as the 15th state of the Indian Union. Dadra and Nagar Haveli, the Portuguese ruled this territory until its liberation in 1954. Subsequently, the administration was carried on till 1961 by an administrator chosen by the people themselves. It was converted into a Union Territory of India by the 10th Constitutional Amendment Act, 1961. Goa, Daman and Diu India acquired these three territories from the Portuguese by means of a police action in 1961. They were constituted as a Union Territory by the 12th Constitutional Amendment Act, 1962. Later, in 1987, Goa was conferred a statehood. 9 Consequently, Daman and Diu was made a separate Union Territory. Puducherry. The territory of Puducherry comprises the former French establishments in India known as Puducherry, Karaikal, Mahe and Yanam. The French handed over this territory to India in 1954. Subsequently, it was administered as an acquired territory till 1962, when it was made a Union Territory by the 14th Constitutional Amendment Act. Nagaland in 1963, the state of Nagaland was formed by taking the Naga Hills and Toensan area out of the state of Assam. This was done to satisfy the movement of the hostile Nagas. However, before giving Nagaland the status of the 16th state of the Indian Union, it was placed under the control of Governor of Assam in 1961. Haryana, Chandigarh and Himachal Pradesh in 1966. The state of Punjab was bifurcated 11 to create Haryana, the 17th state of the Indian Union, and the Union Territory of Chandigarh. This followed the demand for a separate, 6th homeland, Punjabi Suba, raised by the Akali Dal under the leadership of Master Tara Singh. On the recommendation of the Shah Commission, 1966, the Punjabi-speaking areas were constituted into the unilingual state of Punjab. The Hindi-speaking areas were constituted into the state of Haryana, and the hill areas were merged with the adjoining Union Territory of Himachal Pradesh. In 1971, the Union Territory of Himachal Pradesh was elevated 12 to the status of a state, 18th state of the Indian Union. Manipur, Tripura and Meghalaya in 1972, the political map of northeast India underwent a major change. 13 Thus, the two union territories of Manipur and Tripura and the sub-state of Meghalaya got statehood, and the two union territories of Mizoram and Arunachal Pradesh, originally known as Northeast Frontier Agency, NEFA, came into being. With this, the number of states of the Indian Union increased to 21, Manipur 19th, Tripura 20th and Meghalaya 21st. Initially, the 22nd Constitutional Amendment Act, 1969, created Meghalaya as an autonomous state, or sub-state, within the state of Assam with its own legislature and council of ministers. However, this did not satisfy the aspirations of the people of Meghalaya. The Union Territories of Mizoram and Arunachal Pradesh were also formed out of the territories of Assam. Sikkim. Till 1947, Sikkim was an Indian princely state ruled by Chogyal. In 1947, after the lapse of British paramountcy, Sikkim became a protectorate of India, whereby the Indian government assumed responsibility for the defense, external affairs and communications of Sikkim. In 1974, Sikkim expressed its desire for greater association with India. Accordingly, The 35th Constitutional Amendment Act, 1974, was enacted by the Parliament. This amendment introduced a new class of statehood under the Constitution by conferring on Sikkim the status of an associate state of the Indian Union. For this purpose, a new Article 2A and a new Schedule, 10th Schedule containing the terms and conditions of association, were inserted in the Constitution. This experiment, however, did not last long as it could not fully satisfy the aspirations of the people of Sikkim. In a referendum held in 1975, they voted for the abolition of the institution of Chogyal and Sikkim becoming an integral part of India. Consequently, the 36th Constitutional Amendment Act, 1975, was enacted to make Sikkim a full-fledged state of the Indian Union, the 22nd state. This amendment amended the first and the fourth schedules to the Constitution and added a new Article 371-F2. Provide for certain special provisions with respect to the administration of Sikkim. It also repealed Article 2A and the 10th Schedule that were added by the 35th Amendment Act of 1974. Mizoram, Arunachal Pradesh and Goa in 1987. 3 new states of Mizoram 14, Arunachal Pradesh 15 and Goa 16 came into being as the 23rd, 24th and 25th states of the Indian Union respectively. The Union Territory of Mizoram was conferred the status of a full state as a sequel to the signing of a Memorandum of Settlement, Mizoram Peace Accord, in 1986 between the central government and the Mizo National Front, ending the 2-decade-old insurgency. Arunachal Pradesh had also been a Union Territory from 1972. The state of Goa was created by separating the territory of Goa from the Union Territory of Goa, Daman and Diu. Chhattisgarh, Uttarakhand and Jharkhand in 2000. 3 more new states of Chhattisgarh 17, Uttarakhand 18 and Jharkhand 19 were created out of the territories of Madhya Pradesh, Uttar Pradesh and Bihar respectively. These became the 26th, 27th and 28th states of the Indian Union respectively. Telangana in 2014. The new state of Telangana came into existence as the 29th state of the Indian Union. It was carved out of the territories of Andhra Pradesh. The Andhra State Act of 1953 formed the first linguistic state of India, known as the State of Andhra, by taking out the Telugu-speaking areas from the state of Madras, now Tamil Nadu. Kurnool was the capital of Andhra state and the state high court was established at Guntur. The States Reorganization Act of 1956 merged the Telugu-speaking areas of Hyderabad state with the Andhra state to create the enlarged Andhra Pradesh state. The capital of the state was shifted to Hyderabad. Again, the Andhra Pradesh Reorganization Act of 2014 bifurcated the Andhra Pradesh into 2 separate states, namely, the Andhra Pradesh, Residuary, and the Telangana. Hyderabad is made the joint capital for both the states for a period of 10 years. During this period, the Andhra Pradesh should establish its own separate capital. Similarly, the Andhra Pradesh High Court is renamed as the Hyderabad High Court, High Court of Judicature at Hyderabad, and is made common for both the states till a separate High Court is set up for the state of Andhra Pradesh. Thus, the number of states and union territories increased from 14 and 6 in 1956 to 29 and 7 in 2014 respectively. 20 Change of names. The names of some states and union territories have also been changed. The United Provinces was the first state to have a new name. It was renamed Uttar Pradesh in 1950. In 1969, Madras was renamed 21, Tamil Nadu. Similarly, in 1973, Mysore was renamed 21, Karnataka. In the same year, Lakshadweep, Minikoy and Amindevi Islands were renamed 23, Lakshadweep. In 1992, the Union Territory of Delhi was redesignated as the National Capital Territory of Delhi, without being conferred the status of a full-fledged state, by the 69th Constitutional Amendment Act, 1991.24 in 2006, Uttaranchal was renamed 25 as Uttarakhand. In the same year, Pondicherry was renamed 26 as Puducherry. In 2011, Orissa was renamed 27 as Odisha. Table 5.3 Territory of India in 2014, and up to 2016, States Union Territories 1. Andhra Pradesh 1. Andaman and Nicobar Islands 2. Arunachal Pradesh 2. Chandigarh 3. Assam 3. Dadra and Nagar Haveli 4. Bihar 4. Daman and Diu 5. Chhattisgarh 5. Delhi, National Capital Territory, 6. Goa 6. Lakshadweep 7. Gujarat 7. Puducherry 8. Haryana 9. Himachal Pradesh
10. Jammu and Kashmir 11.
Jharkhand 12. Karnataka 13. Kerala 14. Madhya Pradesh 15. Maharashtra 16. Manipur 17. Meghalaya 18. Mizoram 19. Nagaland 20. Odisha 21. Punjab 22. Rajasthan 23. Sikkim 24. Tamil Nadu 25. Telangana 26. Tripura 27. Uttarakhand 28. Uttar Pradesh 29. West Bengal Table 5.4 Articles related to Union and its territory at a glance. Article No. Subject Matter 1. Name and territory of the Union.
2. Admission or establishment of new states.
2a. Sikkim to be associated with the Union, repealed. 3. Formation of new states and alteration of areas, boundaries or names of existing states. Laws made under Articles 2 and 3 to provide for the amendment of 4. The first and the fourth schedules and supplemental, incidental and consequential matters. Notes and references. 1. Constituent Assembly Debates, Volume 7, p. 43. 2. The state of Jammu and Kashmir enjoys a special position by virtue of Article 370 of the Indian Constitution. It has its own separate state constitution. 3. Added by the 18th Constitutional Amendment Act of 1966. 4. Babulal V. State of Bombay, 1960. 4a. This information is downloaded from the website of Ministry of Law and Justice, Legislative Department, Government of India. 4b. Ibid. 5. See Table 5.1. 6. It had no chairman or convener. 7. See Table 5.2. 8. By the Bombay Reorganization Act, 1960. 9. By the Goa, Daman and Diu Reorganization Act, 1987. 10. By the State of Nagaland Act, 1962, with effect from 1st December 1963. 11. By Punjab Reorganization Act, 1966. 12. By the State of Himachal Pradesh Act, 1970, with effect from 25th January 1971. 13. By the Northeastern Areas Reorganization Act, 1971, with effect from 21st January 1972. 14. By the State of Mizoram Act, 1986, with effect from 20th February 1987. 15. By the State of Arunachal Pradesh Act, 1986, with effect from 20th February 1987. 16. By the Goa, Daman and Diu Reorganization Act, 1987. 17. By the Madhya Pradesh Reorganization Act, 2000. 18. By the Uttar Pradesh Reorganization Act, 2000. 19. By the Bihar Reorganization Act, 2000. 20. See Table 5.3. 21. By the Madras State Alteration of Name Act, 1968, with effect from 14th January 1969. 22. By the Mysore State Alteration of Name Act, 1973. 23. By the Lakshadweep, Minikoy and Amindevi Islands Alteration of Name Act, 1973. 24. With effect from 1st February 1992. 25. By the Uttaranchal Alteration of Name Act, 2006. 26. By the Pondicherry Alteration of Name, Act, 2006. 27 by the Orissa, Alteration of Name, Act, 2011.
Citizenship meaning and significance.